All right. What's up, Perps? Let's go live for a little while. See if we can get StreamYard and YouTube to act right because, well, YouTube's going to YouTube. So we'll see. But I've got, let's see, make sure I get this set up. I had an opportunity to be on the Polite Society podcast tonight, and I would have loved to have done it. I love being on with Paul and everybody. But I've also got a gator hunt tonight. So I had to tell Paul I couldn't be on there tonight because I am going to be on an alligator hunt. And an alligator hunt's probably the one thing that I would forego being on Paul's show for because I love chasing dinosaurs. So that's what I'll be doing. Shauna, what's up, my sister? Jason Ewing, my brother, what's happening? Much love to the fam. So pretty much got everything ready for the hunt tonight, and I decided let's do some more oral arguments. Now, this is the two oral arguments that were held not too long back over the California handgun roster. 500 Magnum, what's up, my brother? So I figured we'd listen to these, help me kill a little time for the gator hunt. And hopefully tonight I might be able to shoot some video of a gator hunt, kind of like me and my wife did last year. Probably not as long, but that video or that gator hunt last year was like 4 hours. So maybe I'll just shoot some short videos tonight of this gator hunt. And again, I gotta apologize to Paul, brother. That's probably the one thing I would miss being on Polite Society for is to go on a gator hunt. Because damn, I love gator hunting. It is my favorite type hunting. So anyway, let's do this. Let's go ahead and we will throw the intro out here and we will get started.
This is Sparta!
Hey, boys! Look what I got here!
Hey, where are the white women at?
Right. I got to play the intro, man. The intro is always fun. Well, I got to play it for two reasons. One, Swamp Dog did the graphic for the intro, and then the other stuff's just kind of a conglomeration of stuff from chats with Blazing Saddles and stuff. So it's funny, man. I love it. So let's pull up the first one because there's two. Both these happened back to back, same day. And these are all challenges to California's handgun roster with their micro stamping and all the other BS they got added on. So we're going to listen to these.
May it please the court, Charlie Sorosi on behalf of the California Attorney General. I'd like to reserve 3 minutes for rebuttal. A preliminary injunction is an extraordinary remedy, especially a mandatory injunction that requires the state to take an affirmative action. It was an abuse of discretion to disrupt the status quo by not holding plaintiffs to their high burden. At issue on this appeal are 3 common sense commercial sale requirements for new-to-market semi-automatic pistols. Chamber load indicators and magazine disconnect mechanisms prevent accidental discharges, and microstamping can be a vital crime gun tracing tool. Each requirement passes constitutional muster, but they must be analyzed separately. The district court failed to do so. As to chamber load indicators and magazine disconnect mechanisms, plaintiffs cannot dispute that these features can be and have been implemented into semi-automatic pistols. Since the Boland injunction of the microstamping requirement took effect in the next case, so far, 5 new semi-automatic pistols have become available for retail sale with a chamber load indicator and or a magazine disconnect mechanism. All 5 were existing off-roster models to which manufacturers added one or both of these features. This is in addition to the dozens of pistols on the roster with these features already. Both features are not a, quote, ban on the sale of new semi-automatic pistols.
Now remember, California's got all of these requirements for a handgun to be on their roster for you and me to purchase, everyday citizens. However, if you're a police officer, you can purchase any firearm, semi-automatic, handgun, shit like that. And it's created this huge market in California where if I got a badge, I can purchase these guns, new SIGs, new whatever. I can purchase these and then sell them, person-to-person sale. So I mean, the requirements on this roster are so idiotic, it's not even funny.
Can I ask a going-in question? There was some note in your brief that there was some legislation under consideration with regard to the microstamping. Has that happened? What's happened?
I think Your Honor is referring to Senate Bill 452.
Well, whatever, I don't know the number, whatever you refer to.
It is currently pending the Assembly. It has passed the State Senate. It is before an Assembly committee right now. And what that bill would do is, if it passed the Assembly and was signed by the governor, it would, effective January 1, 2024, take microstamping, that requirement, out of the definition of an unsafe handgun. It would take it out of the roster removal provision, and it would delay the microstamping requirement in a different penal code section until July 1, 2027.
And is that, just in terms of whether we're going to get a part of this case somewhat mooted out, or possibly mooted out, before we have a chance to decide it, what's the likely timing on that?
So the legislature has to decide on that bill by September 14th, and then if it passed it, the governor would have to sign it by October 14th or 15th, I think.
All right, thank you.
As to the chamber load indicator,
now, I will tell you this. Watch the judge in the top right-hand corner during all this. She's not as bad during this one, but especially in the next set of oral arguments. Watch her. She looks like she's over on her phone playing Candy Crush and, deciding what clothes she's going to wear on her next date. She's nowhere near engaged in this case as the other two judges are.
Magazine disconnect features. Plato's response.
In other words, she's already made her mind up. She's going to side with the state. She really didn't give a rat's ass what arguments are being made in front of her.
That they are allegedly unpopular. The manufacturer's perceptions of popularity do not dictate the scope of the Second Amendment and what safety features that states can require.
What are the historical analogs for those two features?
For the chamber load indicator magazine disconnect mechanisms, I would say the best historical analogs that we have are the firearm and gunpowder proving laws from Massachusetts. They're also, we call.
Again, the Mass Act, which is what they're talking about, which was to boil everything down. The Mass Act said that it was a fire ordinance, which basically said, hey, if you've got all this gunpowder, you got all this stuff, you have to store it in a way so that you're not burning down your house, neighbor's house, and everybody else's house. What this asshole doesn't tell you in the Mass Act is the Mass Act proves that private citizens owned cannons, grenades, mortars, explosive shells, along with their regular muskets and regular, pistols. So they focus on the gunpowder. Well, these people had all this gunpowder. What they don't tell you is what the gunpowder was used for. And if someone was, say they had their cannon in their barn and their cannon was fully loaded with powder and they were, likely to set the building on fire, what would happen is it wasn't just confiscated from them. If their cannon or mortar was there and the fire, I can't remember what they were called, they went around, they checked and said, hey, these people improperly stored their cannon with, their gunpowder and everything. What would happen is they would bring them in front of a jury. And if the jury decided that, yes, they were doing things in an unsafe way, this was a jury, those arms and gunpowder could be confiscated. Their mortar, their cannon, their swivel cannon could be confiscated. But what happened with it is the government didn't tell them, no, you can't have these things. Civilians can't have these. If they were confiscated, they sold them back to the civilians. So this wasn't about, oh, you can't have these weapons of war, because they were. You're talking, like I said, cannons with explosive shells, mortars with explosive shells, grenades, bombs. That's everything that the people owned. It wasn't the government saying you can't have these things. It was the government saying You are creating a fire hazard. So we take these things, we are going to confiscate them after a jury trial. But when we do take them, we're going to sell them right back to the public. So it was never about controlling the types of arms that citizens owned. Citizens owned everything that the government owned. Every weapon of war that the government owned, the citizens owned.
Call them inspection laws. In Massachusetts, they were adopted, at least the firearm one, was adopted in 1805, renewed in 1814. In Massachusetts at that time was the leading.
And it's used in a couple of different cases. And why the hell I've never seen a lawyer for the appellants in this bring that point up, I have no idea. Because it crushes the government's case right then and there.
Producer of small arms around the time of 1812. And like the Chamberlain Indicator magazine disconnect mechanism requirements, those laws also sought to reduce the dangers from firearms that were not did not operate or were not used as intended.
Are there? I mean, what are the limits of this argument? Are there? Could the state impose any kind of design specifications for commonly used firearms under this logic, or are there some limits here?
I think the limits, at least for here, for using these analogs, are about, it's not just public safety, but it is also about reducing accidental discharge and reducing the harm that can come from guns when they fire off when the user doesn't expect them to do so.
Right. I mean, those are broad rationales, right? Safety. Does the state have the power?
You could save more lives by just mandating people get firearms training in the simple, 5 rules, always treat it as it's loaded, to never point it at anything you don't want to destroy, beware your target, what's behind it, all that stuff. You could save more lives by simply doing that instead of depriving people of their property and depriving people of their rights. The state arguments are so insane when you actually break them down. I don't see why they wouldn't just get laughed out of court. Besides the fact, again, this is the Ninth Circus, and they completely believe in government control over arms.
Under Bruin to impose design requirements that are either very difficult to meet or commercially infeasible or experimental.
So for the Chamberlain Indicator magazine disconnect mechanism requirements, I don't think those would fall under any of those 3 categories. And I think that would be plaintiff's burden at the plain text inquiry to show that their proposed conduct falls within the plain text of the Second Amendment. I certainly think what is a design feature or a safety feature that can be added to a handgun, like obviously there have to be some limits. But I would say for the Chamberlain Indicator magazine disconnect mechanism requirements, it's clear that those have been and continue to be incorporated into semi-automatic pistols. And it's also clear that they do help prevent accidental discharges. And at least in the Boland case, and as well as the Renna case, we presented one study in this case showing that those features can help reduce accidental discharges. And I think it was the Brady amicus brief, which went into more detail about statistics on how often accidental discharges can happen, whether it's an experienced gun owner or whether it's a minor or somebody else that has access to that pistol.
What, in the case of microstamping, the plaintiffs argue this is commercially infeasible. Let's just, you may disagree with that, but let's just stipulate that that's true. Does the state have the authority to impose a commercially infeasible design requirement?
Yeah, man, microstamping is just so idiotic. One, firearms get dirty when you fire them. So carbon buildup would negate the microstamping. That's one of the biggest issues with it. It's just not feasible. It might work for a few rounds, but then after that, it's toast. But what about someone just pulling the firing pin out of the gun and running it across the piece of sandpaper and removing the microstamp in the first hand place? It's like serial numbers. They act like these things are engraved on the gun. They cannot be removed. It's, and it's a bunch of horse shit.
I think that gets closer, obviously, much closer for the plaintiff to meet their plain text inquiry burden. but then we would still have the opportunity in the historical inquiry to.
Is this really part of the plaintiff's burden, or is it really more your burden under the historical analog part of the inquiry?
So the argument about feasibility is the premise for the argument that these requirements are a, quote, ban on semi-automatic pistols. And because that argument.
It is a ban. If I can make up a rule where a gun has to have a feature that is completely idiotic and will never work, and manufacturers will never be able to do it, because think about it, you would have to put a serial number on every fucking firing pin. So companies that are producing firing pins would have to have the proper equipment to put a separate serial number on every single firing pin they produce. What if I have a malfunction? My firing pin breaks and I've got to replace my firing pin. Then that firing pin no longer matches the serial number on the gun that it was supposed to match in the first place. It's freaking idiotic.
Argument about whether it's a ban is the entire premise for their plain text analysis.
I don't know whether you guys are going to Great Ass tonight or not. I think you guys might just be hanging with Mom, and maybe when Ari and Trev get home, you can go see New Baby.
In the Pena case, it appeared that there was a considerably more robust record about the feasibility of the microstamping than there is here. Basically, the state put on nothing.
Gabber, what's up, brother?
About the feasibility of the microstamping.
So
I mean, I understand that the defense didn't. The plaintiff's witness
Gotta fix that cup of coffee.
himself said it was technically feasible in the sense some of them work sometimes and it could be done. But on this question of, but he also said,
I hear that,
as
Gabber.
of 2005, that it was not commercially feasible because every manufacturer would have to develop their own way of doing it. And the state put on nothing about that. Is that right?
So Pena was a motion for summary judgment. We're at a
I understand
very preliminary.
that, but it makes it difficult to evaluate for preliminary injunction purposes. I mean, you have what's in the legislative findings, which aren't all that robust to begin with, and with case law that seems to be fairly hostile to relying on unsubstantiated legislative findings. So what are we supposed to do with it?
So a couple points, Your Honor. For Renna, there was actually, plaintiffs didn't present any evidence about microstamping feasibility.
I understand, but in Boland, you didn't. I understand, but I mean, it would be a little. Technically, we might be able to come out differently in the two cases. It seems a little peculiar. Anyway, go ahead.
Sure. And the microstamping requirement did recently change as of July 1, 2022, to reduce the requirement from 2 places to 1
Right.
place. So that requirement really hasn't.
But am I correct that the state put on nothing about this?
We did not affirmatively put on evidence about the feasibility of microstamping, but I think if you look at the evidence that plaintiffs put on by Mr. Beto, his own testimony and his study actually shows that microstamping is feasible and can be commercially adoptable.
Well, he did say it was feasible, but he seemed to say it wasn't. And I don't know what he meant by this, but the state didn't explore it. What did he mean when he said it wasn't commercially feasible? I mean, it meant it would cost money because the manufacturer would have to develop, each one would have, there was no plug-in way to do it. I don't know why that's the standard, but the state didn't put in anything about this.
So the study at Mr. Beto's study at 7 ER, I'm talking about the Boland record right now, but at 7 ER 1394, he said that many different implementation strategies for this technology may be possible, and he agreed that in his testimony again in Boland 3 ER 387, that the kind of microstamping contemplated by California law, which uses alphanumerical characters, is
Well,
has the best
suppose
chance.
we had a blank about that. I mean, suppose, because he actually, whatever his actual study was in 2005, he was not qualified as an expert, and he didn't actually.
Dr.
Although
Fudd,
he
what's
said
up,
that
brother?
it is now not feasible. There's nothing in the record to suggest that he had done any kind of study after 2005. So suppose
deal,
we just
Gabber.
washed him out too, and we had a 0. Then what would we do with it? They didn't have any proof that it wasn't technologically feasible. You don't have any proof that it was. But in fact, it's not happening.
So one thing I did remember that we did put on is that the firearm manufacturers or the National Shooting Sports Foundation before the California Supreme Court in 2018 did acknowledge that microstamping in one place on a firing pin is feasible, and that is the current requirement. And
Right, but I mean, just to follow up on this line of questioning, isn't all of this the state's burden if this conduct is covered by the plain text of the Second Amendment? Because at that point, you have to show the how and the why under this historical analogical reasoning test. And it seems to me that once we've crossed the threshold and once there's a determination that the Second Amendment protects this conduct presumptively, then it was the state's burden to come forward and build a record on this point. And there's not much of one here.
so for the historical analogs for microstamping, I think we have pointed to sufficient analogs, and we've met our...
What are they?
So I think it's the analogs that were covered in the district court case in Holton, as well as this court's case in Teixeira. Specifically, there was a 1631 Virginia colonial law that required all firearms that came into the colony be registered. There was a Connecticut and also Virginia law that restricted where firearms could be sold.
Oh, yeah, you're right, Warsaw, they did.
And all these analogs are just part of the tradition of the government controlling commercial access or the commercial market for firearms.
Okay, until 1968, I don't think the government ever required even a serial number on a firearm. The only reason there were serial numbers before was one, to track for military, to track who they were assigning guns to, and two, for manufacturers to track parts and inventory. That also was because in earlier times when guns were being manufactured, all the parts were hand fit. So you couldn't necessarily take a part out of one gun that was serial number 427 and put it in 428 because it was hand fit specifically for 427 as far as the serial numbers on guns. So it was to track parts. These people are idiot. The state, in this case, the government, again, is playing the same game they always play, which is we win, you lose. No matter what logic we come up with, our logic's right. We don't have to prove it. You have to prove that it's wrong. When really and truly, the state has the burden and should always have the burden to prove their case. And they're playing a game of we just get to say stuff and we have to be proven wrong. It's the exact opposite of the way it should go. What's up? Too many choices.
But this isn't about who can buy it.
It's about ensuring
it's
that
about who can buy it,
guns are not used
police
for
can buy it.
illicit purposes, and it's about tracing firearms. And I think Your Honor's prior questions about feasibility and the paucity of the evidence there, I think it's important that any ruling about microstamping here is limited to the record before this court in this preliminary posture, because the record of microstamping can be developed further below. And there are other states that do have microstamping requirements that
There are? What's your other state?
New York and New Jersey.
They actually have it, or they have it prospectively, or they might have it someday, or what?
They have not gone into effect yet. Both states are conducting feasibility studies as we speak, and I don't know the release dates of those. I think New Jersey recently announced that theirs would be coming out.
On the one hand, we often in regulation, I mean, if something is physically feasible, which this appears to be, there was a lot of complaints about airbags, and presumably no manufacturer would have done it if they weren't forced to do it. Airbags are a lot more expensive and complicated, and presumably every manufacturer had to do it somewhat differently. So it is somewhat, bizarre that if something is physically feasible and not expensive, the fact that you might have to adapt it to your particular gun is a reason that proves that it can't be done. You'd rather not do it. But the problem is that we're dealing with the Second Amendment. There's nothing in the Constitution that protects automobiles, or maybe there is, I don't know. If somebody tried to ban automobiles, I think there'd be a problem. But so it's disturbing, but to have this whole, and my problem is that have this whole case hung up on this problem, because as a result of it, it appears that the manufacturers are not putting. You say there are a couple new guns added, but they can't because of the microstamping, right?
They were added because the microstamping requirement is enjoined under Boland. So the 5 new,
really?
The 5 new pistols that were added.
I see. So that's just demonstration that if the microstamping was gone, there'd be more guns on the roster.
I think the short answer is yes, Your Honor. I think the microstamp, because manufacturers have essentially boycotted and chosen not to comply with the microstamping requirement since 2013.
So I hope in the next argument that you will concentrate on the other two provisions.
I'd be happy to, Your Honor. I think I'm coming back up here a couple more times.
Yeah, we'll see you again shortly, but we'll give you 2 minutes for rebuttal, and then you'll obviously have an opportunity to address all these issues further in the next case.
Thank you.
Good morning, Your Honors. Bradley Benbrook for the plaintiffs and appellees. May it please the court. California's Unsafe Handgun Act is an extreme outlier among modern firearms regulation and has no analog in history.
None whatsoever.
Prior discussion just showed that.
Isn't it true that at the time of the founding, basically most guns were long guns, and you had to put gunpowder in the gun and push it with a ramrod and have a little ball, and there were, and I gather that was even true of
firearms is fucking insane.
Smaller guns. So this problem kind of didn't exist.
At the time of the founding, lady, and the state's evidence proves it, your average citizen just didn't own guns. They owned cannons and grenades and mortars and every weapon of war they could possibly own. And they weren't individually serialized, being forced by the state. The fucking ignorance of these judges is amazing to me, considering they're supposed to be presiding over cases that seriously impact the rights, the natural rights of Americans.
So what do we do with that? We're supposed to just stop history and say, because the problem didn't exist, we're simply, there's no analog?
Well, I'd say I have two responses to that, Your Honor. Heller conclusively responds to the observation that guns were very different at the founding. It says that the Second Amendment does cover all guns, all arms in their current manifestation. And the...
But we can't productively look at history for something that wasn't there.
Well, so
we look for analogs, and Bruin is very specific about how to do that. So it would be helpful to me, and let's stay away for the moment from the microstamping. Let's talk about the other two.
Well, so Your Honor, the other response to Your Honor's question, Your Honor used the word problem. The problem, as Bruin categorizes it, is, and as the state categorizes it, is accidental discharge, accidents with firearms. That existed at the founding. And so the analysis under Bruin, in the history analysis,
and insofar as it existed, there were regulations, quite severe ones, about gunpowder and leaving.
Those were all fire
in
ordinances.
the gun,
they weren't ordinances or laws over what you could own, what you could own, what you couldn't.
That characterization, as the district court found, the burden imposed by the proving law and the gunpowder inspection laws.
Well, you characterize the proving laws as being just about whether the guns work as expected, but my understanding is that they have to have standards. They are proving it against something. And there were standards in those statutes about how far they were supposed to fire or how they were supposed to fire and so on. So there were standards.
No, there
Absolutely,
weren't.
there were objective
Not
standards.
like that,
If
no.
a gun worked as it's supposed to work, it would be stamped and available
Well,
for sale.
worked as
These guns,
it was regulated to work, had the characteristics that the government decided it had to have.
No, not like that, lady. And the ordinances you're talking about were all fire ordinances. They had nothing to do with the guns that people could own or couldn't own.
and those were normal operation of guns in common use at the time, firing a certain number of feet.
Right.
These regulations
And
are
if some
seeking to-
manufacturer said, well, I'm sorry, I don't want to have guns fire that long. I want to have my guns are going to fire, not fire as far. That's
Your Honor,
the
these
guns
go-
I want to make. And they'd say, well,
these
too bad, right?
Regulations are totally different in kind because they do not affect normal, well, they do affect the normal operation in the sense that it makes them less easy to use, but they seek to impose features that are not in common use, and that's just
Crabby, what's up, brother?
than the
I
pleading
don't know
law.
if we have any idea whether they were in common use or not. I don't know how long guns
357 SIG is the preferred round for stopping church shooters.
were supposed to shoot at that time. But here, I mean, I find it very hard to understand what the burden is on your client's position is we get to buy any model gun we feel like buying. Even if telling us where the chamber is doesn't change anything about the way we use it, we don't want it for some reason.
So, Your Honor, the recent case in Teeter versus Hawaii forecloses that argument. Hawaii banned a subset of knives.
Well, first of all, Teeter is not final in this court.
Heller foreclosed that argument by addressing specifically that the state can't point to the availability of one set of guns to justify banning another set of guns.
Well, that's a difference between handguns and long guns. This is a difference. I don't know what the difference is. It's a difference between a gun that tells you that there's a bullet in the chamber and one that tells you there's not a bullet in the chamber. And I just don't want to know if there's.
Yeah, like someone can't press check their gun. I mean, I've got one gun with a loaded chamber indicator. It's a Taurus G2C. That loaded chamber indicator has never, I don't know, been some big feature to me because one, I should already know what condition my gun is in. And two, if I have any questions about it, I just press check it. Hey, there's brass in the chamber. Whoopee, it's loaded. Fucking Christ, man.
A bullet in the chamber. I mean, that just seems totally irrational. I mean, not even believable.
Your Honor, the guns that are not available for sale are in common use throughout the United States. There's no dispute about it. Under the textual analysis that Bruin requires, the handguns are arms that are not being available for sale. There's no dispute that there's an auxiliary right to purchase them. There's no dispute that the plaintiffs are among the people. That is the end of the inquiry under the textual analysis.
Is your ultimate position that no safety regulations for guns are valid?
No. Manufacturers of firearms produce firearms. If they produce an unsafe firearm, I present to you the SIG P320. If they produce a firearm that is unsafe, that is when people have the right to bring SIG to court and address that. There's reason that firearms don't fall underneath the consumer product agencies because they would have so many safeties on the motherfucker, you wouldn't be able to use the goddamn thing. You'd have to type in a code, turn off the safeties, load it then.
Well, that's certainly not the import of this case and not the
No, but
import
I'm
of our
asking for
argument.
the import of your position. If somebody says, I'm sorry, I want to buy a gun that if you drop it, it can shoot, and I get to buy that gun if I want to.
That is what you call a product defect, and you can sue the manufacturer over stuff like that. See how this works?
Well, Your Honor, respectfully, it's hard to imagine a plaintiff bringing that sort of case. And I
It's
think
hard
they-
for me to imagine a plaintiff bringing a case saying they don't want to know if there's a bullet in the chamber.
And I would respectfully submit that that plaintiff might have a very hard time with the proving laws.
How do you characterize the burden differential between the proving laws and the gunpowder storage laws on the one hand and the burden here?
Because again, the gunpowder storage laws were about the storage of gunpowder. It was a fire ordinance. It was not the government telling you you can't own this because we say it's not safe.
So on the proving law, again, in terms of the scope, well, first of all, on the scope, it did not require any features. That's an important point. All ordinary guns were eligible for sale if they passed the firing test. Here, guns that are banned can pass 200 tests, but they still can't be sold. And the Massachusetts proving law, which is the primary example, had a very limited scope. It didn't even apply to the Springfield Armory, the biggest manufacturer in Massachusetts, and it didn't apply to out-of-state guns.
There does seem to be an absence of evidence of design rules back at the founding. Is that dispositive?
I think so, Your Honor, under the language in Bruin that says if a societal problem has existed since the founding, and at the founding they either didn't address it or addressed it in materially different ways, and here we're talking about essentially firearm safety, accidents from guns. If that problem has persisted throughout, and they either didn't address it or addressed it in materially different ways, that's the answer.
Does it matter if the technology has changed over time? Because I think the argument on the other side is that the weaponry here is a higher level of technology and capability.
So Bruin accounts for that. It does, and they're leaning very heavily on the language in Bruin that says in the instance of technological change, a more nuanced approach would apply. And we've briefed it as if that applies. We submit it doesn't, and the Brady amicus brief is a good indication of that. They say that the CLI and MDM technology has existed for over 100 years, and yet there has been no jurisdiction until the last few years to impose such a requirement. Now, of course, I hasten to add that in the early 1900s, that wouldn't that's too late to come along anyway, but nevertheless, it's worth observing that while the state leans very heavily on the argument that this is new technology, that we've got to completely change our approach, the Brady brief undermines that.
How do you address the point that was made about the number of pistols that have been submitted and approved with the CLI and MDM, the original 32, and now this additional, I think it was 5?
Your Honor, that kind of gets to the feasibility issue. There could be 50 added, 75 added. The feasibility question, frankly, I believe is a red herring. It does not relate to the text argument. That's that's one of their textual arguments. But you know, the feasibility concept ignores that even if a substantial number of these guns adopted the technology, there's still a substantial numbers that don't have the technology that's in common use. And there's no basis under the Second Amendment for banning those. We're not anywhere near. Maybe in 50 years, we would be to the point where the vast, vast majority have all these features, but that's simply not the world as it exists today. So if I could say one point, a few points about Pena. There's a lot of
About what, I'm sorry?
About Pena versus Lindley.
okay.
There's a lot of discussion in the state's briefs about Pena, and it really animates a lot of the feasibility discussion, the alternative guns analysis, and I have to stress that because of Bruin, Pena really has no application here. The closest Pena got to approximating the kind of test that Bruin calls for was its statement, "We assume without deciding that the conduct protected by the Second Amendment has been burdened." That's the closest they got to something that Bruin requires. The entire rest of the opinion is, one, determining whether intermediate scrutiny applies, and two, applying intermediate scrutiny. But of course, Bruin totally abrogates.
Yeah. Intermediate scrutiny was always an interest balancing test that the state always went for so that they could say no matter what, the state wins. Basically, that's their argument. Bruin said you can't use intermediate scrutiny anymore. If it implicated the Second Amendment, then you had to look at text and history. And if there was no analog with text and history, then you couldn't do it. When you really look at Bruin, it makes all these gun laws absolutely unconstitutional if you actually read the text of Bruin.
Counsel,
Yes.
in your view, has Pena been overruled?
Yes. Yes, absolutely. I mean, as I say,
Every single word in Pena has been overruled, in your view.
well, the background section where it describes the law is not necessarily overruled, but the basis for reaching the result in Pena is totally incompatible with Bruin and cannot be used. And therefore, for example, the state should not have pointed to the statement at the beginning of the opinion in Pena, quote, "We reject plaintiff's claim that they have a constitutional right to purchase a particular handgun." That is the statement of the result of the Pena court's intermediate scrutiny analysis. That obviously has no bearing now. And it's worth illustrating another example. At 982 in Pena, it says that microstamping has not been implemented because manufacturers, quote, "have chosen not to," and that has no relevance after Bruin, but
Why does it have no relevance?
because it followed up that statement a few sentences later that said, that begs the question.
I would think it has no relevance because it's a factual statement. It would have to be, that depends on that record, and it wouldn't matter. This is a different case with a different record, and there's no collateral estoppel, but it's certainly relevant.
Well, it's not relevant to the text.
Not because of Bruin, it doesn't have relevance.
It's not relevant to the text. Well, Bruin says it's text and then history. And
Well, it doesn't text. Do you think that text with regard to the first prong doesn't include text as interpreted in Heller, i.e., regulations that infringe the right to bear arms so that for purposes of self-defense? So at least in the first prong, there should be some analysis of whether this restriction restricts the right to bear arms for purposes of self-defense, right? And if the conclusion is knowing whether there's a gun in the bullet in the chamber does not restrict your right to self-defense, then it's out on prong one, no?
Your Honor, the test is simply facial test. Are arms being restricted? And these are indisputably arms that are not available
And if your
for sale.
conclusion is that the right to bear arms does not include the right to bear any gun you feel like it, and there, as long as you can buy a lot of guns and for purposes of self-defense, that would be a prong one determination.
Well, Heller addresses Your Honor's concern.
Well, it doesn't,
saying,
because there's a huge difference between I'm not going to have any handgun, and I can have any handgun I want, even if it's dangerous.
It says that that the limitation on the Second Amendment right is a limitation of the Second Amendment right is that guns in common use are covered by the scope of the Second Amendment. Your Honor asked about buying any weapon you want. Heller addressed it and said the dangerous and unusual exception historically is an exception. So we're not here saying we should be able to buy a machine gun. We're talking about ordinary guns that are available in 48 other states that many millions of people possess and use because they work well.
Can I ask just before you sit down about just the reach of the argument? in terms of whether there's any ability for a state to impose additional design features, design requirements that other states don't have. Do you think a state has that ability under Bruin?
Well,
I'm talking any ability, right? Because once you change the design feature in one state, there's then going to be models of firearms that are available in other states that aren't quite the same, and that somebody wouldn't be able to purchase if the design is based on different requirements.
I don't think I can stand here and categorically say there's no design feature that can be lawfully imposed under Bruin. All I can say is that these design features that are being imposed clearly are not consistent with Bruin or the historical scope of the Second Amendment.
Now, we know what these so-called design features are all about, and it's about stopping people from getting these firearms. Basically reducing the market down so small that people can't get the firearms that they want to get. And if it was such a safety issue, then why are cops allowed to buy these firearms, these new firearms, and carry them on duty? Think about it. In California, you can't go get a Gen 5 Glock. But guess what? Cops can get them. Cops can carry them. You can't go get the newest SIG. Cops can get them. Matter of fact, the cops can go buy them, and then the cops can go sell them in a person-to-person transfer. So if these guns were so safe, why are the cops allowed to carry them? And when it comes, when we look at it, cops are responsible for more negligent discharges than private citizens.
And if I could just
even if there, I mean, I gather that there are plenty of guns that do. Let's just check with the chamber designator for the moment. There are, I gather, a large number of guns that these people can purchase, hundreds, in California even. Ones that were older models and a good number of new models. And presumably if the microstamping weren't there, there'll be more. That's not good enough? The fact that there are hundreds of guns they can purchase?
No, it's not good enough.
We addressed that in our brief, and
I know, but I want to know why. I mean, it comes down to the notion that they can buy any gun they feel like it. I mean, if they want a gun that's blue instead of one that's red, and it doesn't have the chamber feature, they have a right to buy it. Is that your position?
Well, that's not the import of a blue-red distinction is not the import of the case or the declarations we've submitted. We submitted declarations explaining some of the reasons why people might want other types of models that are banned.
I don't want a gun with a magazine disconnect. I despise magazine disconnects.
And therefore,
but all of this is skewed by the microstamping issue.
Pardon me?
All of this is skewed by the microstamping issue.
Respectfully,
you choose to lump all three together, but if we backed out the microstamping, what's the problem?
It's a huge problem because there are 1,000+ models of guns available throughout the United States that don't have either of the MDM or CLI features. So the problem
for the ones that have been submitted, the 35 plus or 32 plus 5, do those otherwise have the modern features that are available elsewhere? In other words, does the addition of the CLI and MDM somehow affect any of the other features that are now part of a more modern pistol?
Well, the record isn't really, what does Your Honor mean by effect?
Well, what I'm saying is the following. There's a 10-year gap in time, right, between when something was last put on the roster. Again, take aside these 35 for a second. And my understanding from the record is that there's been changes to gun technology over the last 10 years, just like there would be to a car or to a TV. And so there's some new things that people might want in there. For the 35 plus 5 or 32 plus 5 models that have been approved on the California roster that have the CLI and the MDM, do those otherwise have the modern features that are available elsewhere?
Your Honor, that hasn't been addressed. I mean, my understanding is it probably do, but we don't have development of that in the record. I would just close, Your Honor, with 2 points. The mandatory injunction point that counsel raised, we did address that in the brief. But secondly, Firearm technology has been,
Counsel, could you address it here? Why is this not a mandatory injunction?
well, at a big picture level, their argument is, well, this is a mandatory injunction because now we have to receive all these guns and start testing them if the injunction holds, which we wouldn't have.
The state itself doesn't have to do anything but back off on their retarded ass goddamn roster. They don't have to test firearms. Firearms are tested by manufacturers. And if there is a mechanical defect in a firearm, that is for an individual to bring up with the firearms manufacturer in court. If you were injured by a mechanical defect on a firearm, I think Remington 700 suffered from it, P320s, and there's a couple others that I can't think of off the top of my head. But if a manufacturer produces an unsafe firearm, you have the right to take them to court. The state doesn't even have to be involved in this bullshit. And the only reason they're involved in it is to basically shrink the market down to where you can't legally get firearms that you want to get. It doesn't matter that, hey, the next state over, I mean, I can get any gun that I want, and those guns are perfectly safe. It doesn't matter that in California, if I'm a state official, I can go get the gun that I want. And I can go sell that gun to somebody else. Fuck these people, man.
Otherwise had to do. Well, it cannot be the case that the state can avoid an injunction by saying, well, we should be able to keep doing enforcing this unconstitutional law over here because it's going to require compliance with the law as we've written it would have to do some ministerial tasks.
What is the definition of a mandatory injunction?
Well, I think at a big picture level, it's an injunction that.
What's the legal definition of a mandatory injunction?
An injunction that requires certain acts, I believe, is probably the best answer.
To do something that it would not otherwise have to do. Does this injunction meet?
Okay. Going for the definition of a mandatory injunction. A mandatory injunction says the state cannot do these things and they have to basically back off. You can't do it. Just like an injunction against the ATF. Hey, you have overstepped your bounds. You can't do this, so you need to go, I don't know, fuck yourself. And that's exactly what the state of California needs to do. They don't have to perform any other task that's going to cost them any money at all. As a matter of fact, it will save them money and just say, hey, you can't do this. So, hey, go play golf. Go put out a wildfire. Go, manually turn a windmill because the wind's not blowing that day. Do something constructive with your time other than depriving people of their rights.
That definition?
I don't think it does because the state of the law has to be taken as a given, and the state has enacted statutes that said in certain circumstances we do this. So treating gun models that are currently banned as being eligible for sale, being lumped in with all the other guns, cannot fairly be characterized as a mandatory injunction, that marginal ministerial work.
Counsel, if we disagree with you and say that this is a mandatory injunction,
and you know she's going to disagree,
did the district court properly analyze the winter factors in the context of granting a mandatory injunction?
I believe it did, Your Honor. It did address each of the winter factors.
At the heightened standard that a mandatory injunction requires?
Well, in fairness, the district court did not agree that it was a mandatory injunction.
Well, that's why I'm asking you the question. If the district court did not see it as a mandatory injunction, did it amplify analyzed it at the heightened standard that's required for a mandatory injunction.
Your Honor, I can't add anything to that.
Yeah, Warsaw, dude, I've said it plenty of times. Heller was a punt. It was really bad law. Heller should have been a very simple case of the Supreme Court saying, no, DC, you can't do this. All guns can be owned by citizens. You have no power, federal government or District of Columbia, to regulate the arms that your citizens owns, period. The text of the Second Amendment is very plain. Think about it. There were multiple conventions and meetings and drafts of the Second Amendment. They could have written the Second Amendment any way that they wanted. They could have said at that time, citizens can only own the arms approved by government. They could have said that in the Second Amendment. They could have said citizens can only own a certain level of weapon, and they can't own the government or can't own the same weapons that the government owns. All of the debates around the Second Amendment at that time, all of the balancing tests and the interests of the government were taken into account, and then they came up with the very simple text of the Second Amendment as it stands today, as it stood when it was agreed to. And to understand the Second Amendment, you have to understand the language of the time, and that is what matters. It is a legal contract. And what is happening is over the years, over the time, the anti-gun elements in the United States have sought to change the meaning of the words instead of changing the amendment itself, because they know they can't change the amendment. So they try to change the meaning. They try to go with regulated. Oh, regulated. Regulated has to be regulated by the government. No, that's not what that meant at the time. The language that was agreed to and the meaning of the words at the time is what matters. And there's nothing in the Second Amendment that says the government has the right to basically manage or dictate what arms these citizens can own. There's nothing in there that says that they can do that.
What we've already addressed in the brief.
All right, thank you.
We've let you go well over your time, Mr. Benbrook, and we're going to be hearing argument in a similar matter next. So,
No, the state doesn't
if you
care
have a very
about
quick
the
concluding
Constitution or
remark,
what
and then we'll ask to hear from
Constitution says.
rebuttal.
Well, I guess the one note is the various discussions about the evidence in the Boland case. That's a different case, so that's why I didn't respond to that. I'll let my able colleague.
Just in that regard, the record in this case says nothing about the microstamping's feasibility. Is that right?
There, nothing about the feasibility. I mean, there is declaration that no guns have the microstamping technology.
Well, yes, but there's nothing about the feasibility, about why. Nothing.
I don't know that the state certainly talked about the feasibility, but again, feasibility, I just reiterate and close, the feasibility issue and the argument that this law isn't causing the problem because manufacturers are just not complying is frankly Orwellian, and it assumes away the whole ballgame that the state has the ability to impose feature requirements, and by doing so, banning guns in common use. That's the entire point of the law here.
Okay, we're going to ask now to hear rebuttal from your opposing counsel. Thank you, Mr. Benbrook.
So this is where the state gets another kick at the cat.
If your honors don't mind, I'll start with the mandatory injunction point. Our view of what is a mandatory injunction is something that requires a state to take affirmative action, and that's something that disrupts the status quo. Neither the district court in Renna or in Boland actually addressed this issue at all, even though we did raise it in our briefing
I
before
think
the
that all the
district
state
court.
has to do
And
is
because
scrap
neither
their
district
roster.
court
They
actually
don't have to
addressed
spend
whether
a
it was a
dime.
mandatory injunction, neither district court even applied
Matter
that
of fact, it would
analysis or
save
held
the state
plaintiffs
money.
to the higher burden, that they need to show extreme or very serious damage, and that they need to show that the law and facts are clearly in their favor. And I think we pointed.
No, what you have to show, the burden in this case should be on the state, and the state has to prove that there are historical analogs for this, that this has been done since the time of the founding, that this fits squarely within the meaning of the Second Amendment. And the state can't prove that because the state's full of shit and they have no case. This is like many things in today's society. State creates an unconstitutional law, whether it's state or federal, and then they dare you to oppose that law. You have to spend money to fight something that's unconstitutional. And while that unconstitutional law is in effect, it is treated just like any other law. In other words, people go to jail over it. People lose their livelihoods over it. People will get fucking killed over it because they dare stand up to the state.
To American Freedom Defense Initiative as an example of a mandatory injunction where a public transit agency was required to publish an ad on a bus when that ad did not comply with its requirements.
But here, the injunction is simply don't enforce the law, no. Don't do something.
The Boland injunction says the state or the Department of Justice cannot otherwise prevent the retail sale of semi-automatic pistols without the three features that are challenged here, which means that the Department of Justice would have to allow the retail sale of any semi-automatic pistol that complies with the other parts of the Unsafe Handgun Act.
But
lacks those
allowing the
features.
sale just means don't stop it.
No, it means, at least for how this law works, it means that the department has to receive those pistols from the lab. It has to receive the lab report. It has to review the gun. It has to review the lab report to ensure that all the requirements are indeed met. It has to collect the listing fee. It has to notify dealers that the gun.
That's not the result of not enforcing this law. That's
is-
the result of the existing law that otherwise exists.
That is the result of these requirements not being in effect, is that
Right, so
has to-
therefore, what kicks in is what was there before, which is this regime where you have to have, to get on the roster, you have to meet certain requirements. But as far as this injunction is concerned, all it's doing is eliminating a barrier, and we're back to the status quo, which is this is how you do it.
Well, it's changing the status quo, even from, let's say, just with the microstamping part enjoined and not Chamberlain indicator magazine disconnect mechanism enjoined.
Is there anything else you want to talk about?
There are quite a few things I would like to talk about.
I wonder, just to make a suggestion, because you're about to get back up here in Boland
Correct.
and speak on some of these, frankly, identical issues, I wonder whether we should conclude our argument in this case. And Judge Burrs, I don't know if you'd like to take a short recess.
Yes, that would be good.
So why don't we do that? We'll take a. Oh, go ahead, Judge Rawlinson. I apologize.
I wanted to ask if, under the injunction, is the state required to register firearms on the roster that would not ordinarily be registered on the roster?
Yes, Your Honor.
Thank you.
Or add them to the roster, yes.
Yeah, you would be in line with every other fucking state in the union just about, to where people would be able to purchase any handgun that they so wish.
That's correct.
Okay. I want to thank both counsel for the briefing and argument. In this case, we're going to go ahead and submit the case of Renna versus Bonta. The court's going to take a 5-minute recess, and we'll then hear argument in the last. We'll hear argument in our final.
Okay, so this was the second case of the day. And this case, of course, is another case about the handgun roster. And I can't remember which case or whether both cases Reno May and some other guys are involved in. But they're fighting this pretty damn hard. But, you know, the thing, micro stamping. One, like I said, the gun's going to get dirty. It's not going to transfer that serial number to the primer or wherever on the spent casing any damn way. Two, I could buy a gun with a micro serial number on the firing pin, come home, take a piece of sandpaper, erase that serial number. And since it's a micro stamp, I won't even really affect the firing pin. It's still going to protrude properly. It's still going to strike primers properly. I just remove the serial number on the firing pin. And if criminals will go through and remove these serial numbers on, manufactured firearms, do you not think they'll remove the serial number on the firing pin? It's fucking idiotic. And it's just a way for the state to control the guns that people can purchase. Like I said, if it's an unsafe gun, if I buy an unsafe gun and I'm injured by it, or in some way I'm dumb enough and I injure someone else with it, I have redress. I can sue that company.
Matter of the morning, Boland versus Bonta, case 23-55276. And this sort of goes without saying, but because we've been hearing argument in a similar matter earlier, let's try to pick up where we left off, and we'll see, encourage counsel to make new points as well that haven't been raised previously. Please go ahead.
Sure. Good morning, Your Honor. As a formality, Charlie Sorosi on behalf of the California Attorney General. I'll start, again, there were questions about the 5 new models that have been made available for retail sale. Those 5 models were existing models that were off the roster that the manufacturers incorporated a chamber load indicator and or magazine disconnect mechanism into. And I think 3 of those 5 have ambidextrous features that plaintiffs have talked about. And so it's clear that these features can be, the chamber load indicator, magazine disconnect mechanism are features that can be incorporated.
Yes, there are things that can be incorporated into a firearm. However, like I said, I absolutely hate a magazine disconnect. I will not own a gun with a magazine disconnect. It's just another part of that gun that can malfunction, and I don't want to be depending on that if I'm ever in a situation where I have to use that firearm for my safety or the safety of those around me. I don't want to have to be trying to worry about clearing malfunctions and shit, dropping mags, and then, loaded or a magazine disconnect on top of it. No. I want a gun that is safe. Like the P80s that I built, I drop test the shit out of those, especially considering I'm carrying appendix. I don't want an unsafe gun pointed at my junk. To put it very mildly. But again, if it was a gun that was manufactured by a federally licensed manufacturer and I buy that gun and I run it through its paces and I figure out there's something unsafe with that gun, I can either send it back to the manufacturer to have them address that issue, or if I was ever injured because of a malfunction with a gun and it was a defect in the manufacturer of the gun, I can sue that gun company. There is no historical analog of the government being able to tell people you can only own the guns with the features that we say they have to have, and we can update these features whenever we want. I don't remember, anywhere in the Second Amendment that says, oh, you have to have loaded chamber indicators and you have to have magazine disconnects. And yes, I realize a lot of that did not exist during the time of the founding. But throughout time, if this was some serious issue that was where the government could legally and constitutionally update these things, that could have been done. But it's not. A magazine disconnect does not make a firearm any more or less safe. Well, I'd say it kind of makes it less safe in some cases than a gun without one. Loaded chamber indicators. Okay. It's just as easy to do a press check on something, and being responsible with my firearm, that's a personal responsibility. I should always know what condition my firearm's in.
Into semi-automatic pistols of that. Manufacturers have simply chosen not to do so as a standard practice, and by doing so, they're trying to dictate what safety features the state or any state can require or not require. Going, I think, to the historical analysis points that were discussed in the.
Just to tell you what would be useful for me is.
Now, again, during this, especially this set of arguments, watch the judge on the top right. She seems like she's playing Candy Crush on her phone, trying to figure out her next date, ordering off Amazon, anything but paying attention to this case.
Do the history, please, but get back at some point to how you think.
There she goes, looking at her phone.
Because there was some discussion about that.
Looking back at the phone.
Essentially, if there's.
Compare her demeanor to the other two judges.
If there is a gun you can't buy, that is a infringement on within the meaning of the text. And I'd like to hear your position, but go ahead and do the history piece first.
I'm happy to do the plain text, just for logical order. That's totally fine. So for the plain text analysis, I think consistent with Boland, consistent with this court's decision in June in United States versus Alanez, the common use point is only one part of the analysis. It goes to what is an arm. Plaintiffs also have the burden of showing that the proposed course of conduct falls within the plain text of the Second Amendment. And so here, plaintiffs had to show that that the Second Amendment guarantees commercial access to semi-automatic pistols or.
Well, if you have the right to keep and bear something, you first have to acquire it, whether you build it or whether you purchase it. You have to be able to acquire it. And that's been argued in court before. To do this, we have to be able to acquire it.
Subset of handguns without public safety features, and plaintiffs do not show that.
She might be fired.
A presumptive right to purchase firearms that are in common use, which these are.
Again, that is their argument, but common use, again, goes to what is an arm. And I think if you just rely on common use, that's conflating the arms question with the proposed course of conduct question.
Doesn't it matter what the variability is between what's the differences between what's in common use and what isn't? In other words, does the right to bear arms include the level of nuance and differences between guns that they're claiming?
I think
I want to, most guns are green, so I want a green gun.
I think as Teixeira said, the Second Amendment does not elevate preference and convenience above all other considerations. And so I think the fact that they want to purchase a specific gun without public safety features is something that we would say that the text is not, the plain text is not guaranteed.
I mean, by that logic, shouldn't Teeter have come out the other way?
So Teeter looked at common use as one part of the question. It also looked at the proposed conduct, and Teeter was an absolute ban on possession and sale of butterfly knives. And this is not by any means an absolute, we would submit it's not a ban at all, but even if you were to accept plaintiff's position that it's a ban on off-roster pistols, it is not an absolute ban because there are still revolvers available and the hundreds of semi-automatic pistols that are on the roster.
That was a whole type of weapon. I mean, apparently it's distinct. I gather it has been distinct for many years. These
Look at her. Back to her phone.
Minor variations within semi-automatic pistols. That's basically what we're dealing with, right?
Yes, Your Honor, I think so.
And there are variables, but they're not. No one's banning semi-automatic pistols or even semi-automatic pistols with certain generic features. They're not even saying anything about the existing features.
Correct. It's just a condition of commercial sale, and so long as manufacturers meet those requirements, then those semi-automatic pistols can be available for retail sale, as has been shown or seen with the five new pistols that have been made available for retail sale with a chamber-load indicator and or a magazine disconnect mechanism.
Okay, you want to talk about history?
Yes. So to, I guess, start at the top point, which is that accidental discharge is not a new problem and has been around since the time of the founding. Our point is
Yes,
specific
and
to
police
weapon
officers,
here,
law
specific
enforcement are
semi-automatic
responsible for more
pistols,
negligent
which were not
discharges than
invented until the
anybody
early
else.
1900s, were not introduced into the civilian market until I think around the time of World War II. And the way a semi-automatic pistol works, where it is not immediately obvious that how many rounds you have, whether there is a round in the chamber, is completely different from the way that muskets and pistols worked around the time of the founding, where you would manually load your weapon and the weapons could not.
Yes, because you didn't have the self-contained metallic cartridge at that time. So there were a lot of things that were tried with firearms technology to make arms repeating arms or to fire more rounds, volley guns, the puckle gun. There were all of these attempts as technology progressed to make firearms repeating arms. I mean, all the way to when you get to, the repeating Henry rifle. That didn't have a magazine disconnect. That didn't have a round counter on the side of it. That didn't have a freaking loaded chamber indicator and all these other damn features that these guys are looking for. And I will guarantee you, if you meet every damn requirement on that roster, they're just going to add in another requirement and then another requirement and another requirement.
I mean, the practice, as we, I think, showed in our historical experts' declaration, the practice was that those weapons were not kept loaded because gunpowder was so corrosive. And so for us, the change, the dramatic.
Again, getting to the Mass Act, that was a fire ordinance. And it's still, I don't see why the person for the appellants doesn't get up there and show the Mass Act and show, hey, this didn't say that people couldn't own these guns. It was just a fire ordinance. And this is proof that people owned all of these weapons and the government had no say-so in it. And even if the government did confiscate a gun after a jury trial, it was sold right back to the public. It wasn't a restriction on the types of arms that people could own. There was nothing about the features or function of the firearms people could own. And it was more about weapons in general, cannons, swivel cannons, mortars. They had grenades, they had bombs. That was all privately owned.
Technological change is the development of semi-automatic pistols and the
And
risk
yeah,
of
she's
accidental
right back to her
discharge
phone.
specific to those weapons. And I think the overarching argument that plaintiffs make that we have not identified an analog that imposes or requires mechanical features.
So if they're grinning and
akin to
smiling,
demanding a historical twin, which we know Bruin does not require. We've shown that the burdens are comparable. We've shown that the justifications.
You haven't shown these burdens are comparable.
And just the simple fact that
As to the proofing and also as to the gunpowder restrictions?
yes, Your Honor. For the gunpowder restrictions, gunpowder was an extremely corrosive item. It would absorb moisture and could easily detonate accidentally when exposed to heat. And so the restrictions, such as the ones that
DM, what's up, brother?
The other inspection gunpowder, I'm sorry,
I thought there were
storage.
many gunpowder restrictions.
There were many gunpowder storage restrictions, and those
Yeah,
intended
DM, you're
to
right,
ensure
yeah.
that the gunpowder didn't unintentionally or prematurely.
Sooner or later, they'll link micro-stamping to
similar
climate
to
change or some
chamber
shit.
load indicators and magazine disconnect mechanisms help to prevent the semi-automatic pistols from firing when the user does not expect them to fire because the user thinks it's unloaded.
Why don't you walk through your argument on the nature of the burden, the comparative burdens from the historical analogs as compared to these, and why you think it's analogous?
So I think for the proving laws, the burden there
She
was
is
it had
full
to
on
inspect,
checked
they had to
out of
inspect
this
every
whole
firearm
discussion.
that went to market. Here for the chamber load indicator, magazine.
She's on her
disconnect,
phone, leaned down. She ain't paying
and also
attention to
micro-stamping.
shit except whoever she's texting or messaging.
Once a couple models are tested,
Maybe she's
and
searching
passed,
Amazon.
then, and is added to the roster, that model can then just be sold. Not every firearm sold commercially then needs to be inspected. So I think the burden there is completely different, and the burden of the proving laws was actually greater than the burden here. As to the gunpowder storage laws, Heller tells us that those laws did not burden the right of self-defense, and I think this is where Pena comes in, when it did the severity of the burden analysis, which is relevant.
Is that what my son?
When you're evaluating comparable burdens, that is relevant. What Pena did is relevant to that analysis, and Pena said that these requirements impose almost no burden on the physical exercise of the Second Amendment right. And I think the
gunpowder restrictions pose a substantial burden, as I understand it, because if the gunpowder is over there, then you don't have it with you in your house over here. Or if it's, in a certain place. In other words, if you want to use the gunpowder, you have to go get the gunpowder.
Right. So the burden for the gunpowder, I'd say it's comparable, or the burden from the gunpowder storage laws were at least comparable to the burdens here.
Well, they're much greater.
Or more, or I was going to say, or greater. Heller discounted the burden of those laws, but that was when it was comparing it to an absolute ban on the possession of handguns, which again is not what we have here. The Unsafe Handgun Act has nothing to do.
So you're only banning it a little bit. Little bit of ban.
Well, I mean, it somewhat does.
Just
you
this
can't,
encroaching
you can't buy them. You
ban.
can't possess them.
Correct, but it does not restrict possession of officer guns. But yes, I see your point that once you need to buy.
And it's an odd feature of the. I mean, both sides seem to take advantage of this or argue it in their favor. That you nonetheless, despite these not being approved on the roster, you can still get them in California by buying them through a private transaction or through some other means like that. You just can't get it from a retailer.
That's correct, Your Honor. And I think that's similar to a lot of consumer product safety regulations where the primary commercial market is regulated, but the secondary market allows for exceptions.
I mean, does it undermine the state's interests here that these are being allowed to be purchased?
Oh, girl up there on the
through other
right, man,
means,
she
that law
is just
enforcement
not
can have
having
them,
this
all these
little
other
argument
things
at
we're
all.
told
She's
in the
already made her mind
exceptions?
up. She knows she's going to side.
So
with
I think
this
law
thing.
enforcement exceptions are common in firearm laws, and the law enforcement exceptions are not, I think, relevant to the Second Amendment analysis. In Pena, they raised an equal protection claim based on the law enforcement exceptions.
So think about what he's saying there. Well, these exceptions aren't relevant to the Second Amendment. What we're saying is if you are an agent of the state, you can own something. But if you're one of the plebes, one of these normal people out here, you can't have that. You can't have your average citizen out there being able to own these things. But you can still get them in the secondary market. We're not stopping that. We're not saying it's illegal to have these things. You just can't get them from an FFL. You can't go purchase these from an FFL, which all it does is it drives up the prices on the secondary market and basically prices people out of being able to own a lot of these guns.
And that claim was rejected in large part because law enforcement officers have far more training in firearms handling and storage.
Bullshit. If that was the case, then why do so many law enforcement officers shoot themselves or other people with negligent discharges if they are so trained? Most cops, your average person buying a gun who is a person who's going to carry that gun for self-defense, even if they don't go out and get formal training, they still do a ton of training on their own. I'm one of those, and I do have some formal training. With Warrior Poet, I went up there for a couple of days, and it was great training. But even with the training I've done on my own in firearms handling and use, I guarantee you I've put more rounds down range than a lot of people who carry guns for a living as far as officers go. I guarantee you I can outshoot them. I guarantee you I'm safer with my firearms than they are. Even some people in the military. I know guys that were in the military that are combat vets, but when it comes to firearms, the only thing that they really know is point the pointy end downrange and shoot where everybody else is shooting. That is the level of their training. They're not great at handling firearms.
Than does the average civilian. And so I don't think the law enforcement exceptions carry the weight that plaintiffs think they carry here. And getting back to the historical inquiry, I think there was also an argument in the prior case that we think that the analogs we put forward are more than sufficient to show a historical tradition of regulating firearms to prevent accidental discharges or to prevent defective firearms. But there was an argument that there was too much silence by other states, or we don't have enough analogs. And so I think the plaintiff in Renna was getting to what is an outlier. And Bruin doesn't really specifically say what is an outlier. It, I think, sets forth maybe a few factors, but I think the primary one.
Well, the outlier discussion in Bruin is about historical analogs. It's not about the regulations itself being an outlier, is it?
Right, I'm sorry. I was in the context of the historical inquiry, and I apologize. I am jumping around, but that is correct. And I can talk about why California is also not an outlier for the modern regulation, but as to the historical regulations, I think the primary concern in Bruin was whether there was contradictory evidence across time periods or jurisdictions. And that's simply, there's no contradictory evidence, and I think.
Well, there's a big discussion in the briefs about whether Massachusetts, on the proof statutes, whether Massachusetts really was a major gun manufacturer, and whether one, I guess 2 states is enough. I guess there were 2 states that had this proof thing, is that right?
So Massachusetts and Maine had the firearm proving laws, and then there were 5 states that had the gunpowder inspection laws, including Massachusetts.
And I thought there were more. I thought there were many, many gunpowder restrictions. There were inspection laws, and then there were storage laws, and then there was even one state or a couple that had rules about not having guns loaded with gunpowder even in your house, and so on.
Correct, Your Honor. The 5 gunpowder I mentioned were just the inspection laws, where they would, similar to the proving of firearms, they would inspect the gunpowder to ensure it met certain quality standards. There were also several gunpowder storage laws that we cited in our briefs, and there were also, I think, pre-founding, I think we cited 3 colonies where they had purchase orders for weapons that required the proving of firearms as well. And so I think the fact that other legislatures did not impose similar requirements in and of itself is not dispositive, particularly here when there is no contradictory evidence across the time periods or the jurisdictions.
You raised an issue that I was going to ask about, which was the outlier point. Is California an outlier on this today in terms of imposing these restrictions? And if so, in your view, does it matter?
The short answer is no, that California is not an outlier. So firearms are outside the federal jurisdiction of the Consumer Product Safety Commission. And so consistent with McDonald, states have devised social solutions and come up with reasonable firearm regulations. And California has done that here to ensure that the firearms that are commercially sold are not defective and do not, to the best extent, do not accidentally discharge. And
how many other states have the CLI in it?
Be great if I unmuted myself. Why is it if these firearms are so unsafe, then an officer, someone with a badge, can go buy one of these from an FFL and then go sell it on the secondary market, and that's completely fine. That's completely legal. If a manufacturer produces an unsafe product, that is where consumers, us, the end user of the product, have the right to sue the company. for producing an unsafe product, especially if it causes injury. It's not the state's job to tell us what firearms are safe enough for us plebes to use, while state officers can go purchase those firearms completely legally. Oh, well, civilians don't have that level of training. No, we probably have more training.
MDM requirements?
So Massachusetts has a requirement that it has a chamber load indicator or a magazine disconnect mechanism. Massachusetts and Maryland have handgun rosters, as does Washington, D.C.
Handgun what? I'm sorry.
Handgun rosters.
Oh,
So like
okay.
California has the roster,
Right.
Maryland and Massachusetts and Washington, D.C. also have rosters. As I mentioned earlier, New York and New Jersey also have microstamping requirements. I think New York and Massachusetts also have.
Well, they don't have microsoft requirements.
Well, they have microstamping
They
requirements.
have attempts to just determine whether they're going to have microsoft requirements.
Correct. I would say they're not in effect. They're not in effect yet.
But does any state have both CLI and MDM requirements besides California?
No. California is the only one that requires both, but there are other states, like I said, that have drop safety and firing test requirements, and 5 states have melting point tests. And I think the fact that states are taking different approaches in this regard.
What the hell is a melting point test? I'm going to have to look that one up and get into that one a little bit.
I don't think it means that just because California has taken this approach, it means it's unconstitutional.
Do you know whether there are other safety regulations being contemplated or possible, or, I mean, in terms of this kind of rule, a rule about how existing guns have to be made safer? Are there other examples?
I think New Jersey has something called a smart gun roster that has also not really gone into effect, and basically.
If these guys were so worried about gun safety, where are the bills out there that are like tax credits for getting firearms training? Hey, you want to pay for this, firearms training so you can safely, handle your firearm? Well, how about a tax credit for that? You show proof of the class, we give you a little kickback. Where's stuff like that? Where is the push for firearms training in our schools? If they're really worried about firearm safety, instead of just restricting the guns that can be sold from an FFL, but if you're a cop, you can still get them and you can sell them to whoever else.
The way I think it operates is that once a smart gun, which is, I think, defined as a gun where it only fires based on your palm print or your thumb print. Once a smart gun goes to the New Jersey roster, then
Like a computer these days.
every dealer in New
what's up,
Jersey has
brother
to
man?
carry one quote-unquote smart gun. So I see I'm very low on time, so I'd like to reserve the remainder of my time, if that's okay.
Okay, thank you.
Thank you.
Good morning, Ms. Murphy.
Good morning, Your Honors, and may it please the Court. Erin Murphy on behalf of the plaintiffs. For the past decade, California has deemed handguns too unsafe to be sold to law-abiding citizens if they lack features that literally no handgun presently has. As a result, California's commercial handgun market has effectively been frozen.
Many handguns, or some handguns, do have the
Some handguns have loaded chamber indicators and have magazine disconnects.
That's correct, but by California's
Whoopee.
terms, those handguns are still unsafe because they do not have microstamping, which is a necessary qualification under California law to deem a firearm safe. So by California's terms, literally every firearm, every handgun on the market is unsafe.
Yeah. And again, these judges argue, and the state argues, like none of these things could be defeated. Oh, it's got to have a micro stamp on it. Well, that's like 2 seconds and a piece of sandpaper, and that micro stamp is gone. And again, that micro stamp under their law has to match the firearm. Well, what happens if I just switch out the firing pin? What happens if my firing pin breaks? Do I have to custom order another firing pin that has the same serial number? It's just, and they know where they're going with this. They know it's an incremental encroachment so that they can just throw on more and more and more and more rules so that they just eliminate more and more firearms. In any of these laws, there's always the exception for law enforcement written in. Hey, you, the plebe, can't own these things, but these law enforcement officers, well, they can own those. They are trained. Most law enforcement officers are lucky to know which end of the gun to point down range.
And the ones that have come onto the market in the past 10 years are too unsafe to be sold to law-abiding citizens, to ordinary law-abiding citizens. They, meanwhile, are perfectly safe, apparently, to be sold to California.
I think you'd do better if you concentrate on the chamber designator and the.
Yeah, that's in Warsaw. You're right there. And what happens? Does it stop someone from using that gun in a crime? No. You can throw loaded in chamber indicators on stuff, magazine disconnects, whatever. You're not going to stop someone from NDing with a gun. It's that person's responsibility. Whenever I have my gun on me, I'm responsible for everything that firearm does. And unlike with a car, and they use the analogy of cars all the time, when I drive my truck on the road, I am interacting with everybody else that is on the road. When I carry my gun doesn't interact with anybody but me. The only time my gun would interact with somebody else out in public is if I had to pull that gun and defend myself or others. And either way, I'm responsible for everything that happens with that gun. That is me when I'm carrying it. That is my responsibility.
Magazine disconnect, because the other it has.
Yeah, Tom DeVore is real good, man.
Lumping them all together does not help the analysis a lot.
Absolutely, Your Honor. I mean, we actually think they require a different analysis because the state's justification for them is different. But I'm happy to.
All right, so
start
to come
by
up here and tell us
focusing.
that there are none, but they're not none with regard to the other two.
That's correct. But you know, just to start with, and where I'd start and where the analysis should start here is the plain text question, whether what we have asserted here implicates the Second Amendment. So to start there, we think that the district court was absolutely right to say that that's really not a close question. Bruin instructs that the way to analyze that plain text question is simply to look at the conduct in which the individual wants to engage. And the conduct we want to engage in here is simply acquiring handguns. Acquiring handguns that there's no dispute are common handguns, no argument here that these are unconstitutional, kind of dangerous and unusual arms or something that otherwise takes them outside of the scope of the Second Amendment. These are just common arms.
So is your position that the right to bear arms is infringed if you can't buy any new version of a handgun?
Yes. If you were stopping me from buying a legal product, and they are legal products, then yes, you are infringing on my goddamn rights, lady. How hard is that to fucking understand? The argument is, well, you can go buy these other guns. Okay. Functionally, they're the same goddamn gun. You pull the trigger, a bullet comes out of the gun and goes where that gun is pointed.
That may be created. Is that the problem?
Our contention is that conduct is presumptively protected at the first.
No matter what the nuance is, no matter how much difference it makes, no matter.
There's not a whole lot of nuance in the Second Amendment.
What the reason is that, what the problem is with the requirement and how it would burden your right to bear arms. Just you have a right to buy a handgun that's on the market because it's on the market. Presumptively
at the textual threshold, yes. The how and the why and the burden and all of that is absolutely going to matter once you start asking whether the state has a justification for restricting the ability to purchase a handgun.
What's up, Brother JLN?
Under Bruin, that would then be kicked all over to the history provision?
Correct. The how and the why is what matters at the historical analysis. You examine the how and the why of the modern law.
No matter how minor the differences between the guns, or no matter how little the restriction, the regulation affects your use of the gun, makes no difference.
Yes. Any infringement, no matter how small, is an infringement. Seems simple enough.
At all.
If the state wants to restrict your ability to, in some
Buy
sense,
any
to
old
acquire
gun.
the handgun, absolutely. And I don't think that's all that radical of a proposition. I mean, if the state wants to put like a 1 cent tax on buying books, we
Oh,
don't
girl
say, well,
up
you know
there
what,
on the
that's
left,
negligible,
boy, she's
so it
just
doesn't even implicate the
checking
First
out
Amendment.
again.
I mean, it's a state restriction on presumptively constitutionally protected conduct. And whether it's a minimal restriction, sure, that's going to matter when you start looking at the how and the why and comparing it to historical laws. But the threshold question is simply designed to basically ask, are you restricting the right to keep and bear arms? And if the state passes a law that says, we're going to take a bunch of arms and say you can't buy them, I mean, it would seem sort of extraordinary to me to think that that wouldn't even implicate the Second Amendment.
Just to understand what's doing the work here in this, so if California were to impose a design rule that ended up excluding one model of semi-automatic pistol, but you could get the other 999, is that the same case as this one?
At the threshold, at the textual inquiry, if
How about on the
somebody
back end?
On the back end,
Now remember, it's not a complete ban on these things because a government or a state officer can get them and then they can go sell them to a private citizen. You just can't buy them from an FFL. In some ways, I think, how can this not be attacked under the Commerce Clause? Because they are affecting commerce by banning the guns or restricting the guns that these FFLs can sell. If they're sold everywhere else, just about the United States, and they're proven to be safe everywhere else in the United States, how is it they are so unsafe in the state of California? Is the state saying here that Californians are so fucking stupid that we have to protect them from themselves by restricting the type of gun they can buy? The nanny state of the government. You little poor bastards in California. No, I'm sorry, you're just too goddamn stupid.
it's all of that's going to, I mean, we want to shift to history, and it matters. You are, because Bruin says you look at the how and the why, and the how basically means you look at the degree of the burden as compared to historical laws.
He did something.
And it might be a very different case if you could demonstrate, that the degree of the burden was such that almost nothing at all is kept off the market.
He's coming here. I've kissed on it. I went in the living room, kissed on it.
The situation was, as Judge
Bro, what's up, bro?
That's it. And the restriction's no good.
Well,
And you couldn't find an analog because the problem is, or it's an innovation that simply didn't exist.
So Bruin addresses that by saying there's a more nuanced analysis for historical.
Yeah, I don't see why the Commerce Clause isn't used to go after like the restrictions on polymer 80s or stuff like that. It's a legal product sold in between states. I don't see why the plaintiffs aren't going after the Commerce Clause here. The Commerce Clause, I hate the fucking Commerce Clause with a passion. It has been so overexpanded as to give government the right to control anything they want by simply saying it moved in interstate commerce. I don't see why we can't argue the opposite. The government here is destroying jobs, destroying interstate commerce. They're affecting millions of dollars in interstate commerce.
Analogs when you're dealing with technology that didn't exist at the time of the founding. So it doesn't mean, just
The smart guns, for example.
Sure.
As
Old judge up top's
described,
checked
it's not
out
going to
again.
restrict anybody from buying a gun. It's just going to assure availability. But if somebody developed some gun that was easy to produce and that just would never was like a self-driving car. It was a self-shooting gun that knew exactly how to shoot and when not to shoot and so on. There'd be no historical analog, and that's it. You couldn't specify it.
No, I don't think that's the right way to think about it, because you just have to if you're dealing with brand new technology, smart guns, I don't think that, I wouldn't stand here and say, oh, there's no laws about smart guns, so we win. You do historical analysis at a higher level of generality when you have new technology. But the question you'd start asking is, okay, how does a smart gun feature actually impact the right? And while it may sound good in theory, a lot of people think it's a problem to have a gun that nobody can fire if they're biometric.
Yes, because we all experience issues with these where the biometrics I use to get into my phone, if my hands are dirty or something like that, I can't get into my motherfucking phone unless I type in this code. So having a smart gun, which I'm not against smart guns, I'm against the government mandating smart guns. If someone wants to own a smart gun, hey, more power to you. But with firearms, there's already enough stuff that can malfunction on a good firearm. Why do I want to add in more features that can malfunction? Be running around my house with a fucking axe murderer chasing me, screaming, "Hey Siri, unlock my gun." No. I want the son of a bitch to where I pull the trigger and it goes bang. I want it to where if something happens to me, my wife can pick that gun up and pull the trigger and it's going to go bang. Well, I don't want to be running around trying, oh shit, my hand's dirty. I got to fucking put my fingerprint on there. No, I don't want it electronically fucking controlled.
Aren't attached to it because it means maybe other family
Technology's
members or
great
somebody
when it
who
works.
needs
It
that in that
sucks when it
self-defense
doesn't.
situation might not
And
be able to
guess when
fire it.
it's
So
going to
you have to
fail?
then analyze,
It's going to
yeah, it's
fail,
new
and you
technology,
need
but
it
how
to
does it
work
impact
at
it? And I
the
think that's
worst
exactly what the
time.
state kind of wants to elide here. Take something like the magazine disconnect mechanism. I mean, that the state wants to just call that a safety feature. It's actually a feature that alters the operation of a handgun. It means that somebody who wants to fire the round in the chamber cannot do so. Many people, including law enforcement all throughout California, they want firearms that can fire the round in the chamber in the event you have a problem with the magazine, if the magazine comes out or whatever it may be.
So this is an argument that the magazine disconnect mechanism actually has an impact on self-defense. Does that argument apply for the CLI?
There is, we did submit testimony below about how the CLI actually has some functional impediments that is part of the reason people, and it's partly owing to the fact that California has like a particularly demanding conception of a CLI because while there are some firearms on the market that have something that functions as a loaded chamber indicator, California requires it to be like visible and have language or pictures or something, and it typically ends up being a bit of a distraction from the sight, which is part of why a lot of people don't want the kind of chamber load indicator that California is mandating. So it is, it's less, I think, of an interference than a firearm that actually won't fire when you pull the trigger and there's a loaded round of ammunition in it. But it does have functional impacts on a firearm that probably explain why California's particular variant of CLI has not become common anywhere in the marketplace. People just don't want to pay for a feature that, also is not something the average firearm owner is going to rely upon, since the first rule of firearm safety is it's your responsibility to ensure, regardless of whether there's a CLI on it, whether your firearm.
Right. I guess what I'm trying to understand is, there's talk at a high level about design requirements, and I'm trying to understand, are there differences within that broader category in terms of requirements that affect the right to self-defense and those that may not?
Yeah, and I think there are to me this gets to the how of the proving laws and why they're so different from what we're talking about here.
Tell me why that is.
Because proving laws were about ensuring that a firearm wasn't defective, that it did what it was supposed to do when you pulled it.
Proving laws are the same thing that happens every day in firearms manufacturing, where you have quality control, where they functions check the gun and make sure that it is operating correctly. Oh, this gun's operating correctly. Let's put that out for sale. Oh shit, this gun's not working properly. We're going to send it back, have it reworked, and then see whether it will function. Again, that's to the manufacturer of the firearm. And even they said the manufacturer, or these proving laws, didn't even cover the biggest armories in the United States at the fucking time. If I get a defective firearm from a manufacturer, I can sue them. And then it's a situation where no one is in jeopardy with the state unless I could prove that that company put out this firearm knowing good and damn well it was defective, people got harmed, and then there could possibly be some criminal implications for the manufacturer, but not for the private citizen.
I thought that there were specifications.
There were specifications, but they were designed to enhance the qualities of the firearm, not to, kind of minimize them. They were, you can't have a firearm that doesn't at least do this much. We want to make them, we want to ensure that they have a high quality,
That seems almost more intrusive. I mean, because if somebody wants to buy a firearm that doesn't do that but does something else, why can't they?
And there just is no indication historically that anybody wanted firearms that didn't at least fire when you pulled the trigger and fire a certain distance. I mean, basically the laws took what was the industry standard of what everybody wanted in a firearm and said, okay, you got to have at least that. But if they said...
I find that difference fairly ephemeral. I mean, because it was
Daniel Lynn, my brother, what's
there
happening?
were no standards, but there were standards.
I mean, I take the point that there were standards, but ultimately what you were doing was ensuring that the firearm did what the person purchasing it was promised it would do, which is fire when you pulled the trigger. The main thing was to ensure...
The answer to that fire is they wouldn't. And I don't want to be in a situation where I have to use my gun in a defense situation. Say I'm at home, someone kicks in my door. I don't want to have to check the fucking charge on my gun. Oh, hell, I forgot to charge it. Or, oh, the charger came out of the wall unexpectedly, so my gun's dead. It's just another fucking layer of bullshit. Now, if someone wants to own a smart gun, more power to you. That is your groove. I just don't think the government should be able to mandate that shit. And honestly and truly, you could mandate it, and us, people who try to obey the law would try to obey the law. What do you do with the 400 million or more, it's probably well over that, of firearms that don't have that technology built into them? Because I promise you, the criminals ain't going to line up at the fucking crack house to go get a goddamn smart gun.
Person had showed up in 1810 and said, well, I'm sorry, but I would rather have a gun that isn't improved and it'll be cheaper. I'd rather have a cheaper gun. I'm willing to take my chances.
Well, yeah, some people can't afford a high-end gun. They go get a Sky. They go get a High Point.
Under your theory, at the first end, does he have a right to do that?
At the textual threshold textual inquiry, you're talking about an arm.
Yes.
But I think that would be, just to put it in more concrete terms, I think this would be a much harder case if we were in here challenging the drop safety requirement. Because if we were in here challenging the drop safety requirement and saying, we want...
But again, a gun being drop safe is on a manufacturer. And if a manufacturer produced a gun and said, hey, this gun's not drop safe, it's still up to the consumer whether I purchase that firearm or not. Again, P320s, which, I don't own a P320. I own a MUP-1 build that I have. And I check that gun for being drop safe because I don't want something that's not drop safe. I'm sitting here at my desk, and any gun that I build, I drop multiple times to ensure that it's not going to go off. But that's up to me.
Want to purchase firearms that when you drop them indiscriminately fire anywhere.
But suppose at the time that those, it's probably true that at the time that those rules were put into effect, the most guns do not have that protection. And somebody says, well, the generally available guns don't have it. I don't have a right to buy the guns that exist.
Top right is completely
sure, and I think just take historically, if proving laws had instead said
but you would still say at the front end that person had that was in the protection.
Yes.
All right. So then you'd have to get to the history part, and you'd have
Look
to
at
find some
her
analog
demeanor versus the other
to a
two
dropped
judges.
gun.
And I think it would be much easier for the state to argue that a drop safety requirement is more akin to the proving laws. It's ensuring that just as part of the proving test was ensuring that the firearm wouldn't explode when you pulled the trigger instead of firing or just completely malfunction. It's ensuring that the firearm won't do something you don't want and expect it to do. And I'm talking here about, not because you're under a misconception about whether it's loaded, but people generally don't want their firearm to just go off when they inadvertently drop it. That's considered, by most people to be a defective thing you don't want in your firearm.
judge is
And so I
way
think
out
that's
there,
why the
brother.
state, if we were talking about, if we were here really challenging that, which I don't think it's surprising that you haven't seen a bunch of people challenging drop safety testing, the state would have a better argument about that being more akin to the old proving laws, because it's really about whether ensuring that a firearm isn't defective and meets the consumer's expectations. But what makes this law completely different is this is saying, no, we don't care about the consumer's expectations, even if the consumer doesn't want their firearm to not be able to fire the round that's in the chamber, or finds a CLI to be a distraction that might be problematic when they're trying to fire it. We don't care what the consumer wants. We're mandating that you purchase a firearm that has those characteristics anyway. That's what the state hasn't shown any
I
historical
understand your
analog for.
argument. What about the gunpowder restrictions of various kinds?
Sure. I think the first fundamental problem the state has is a completely different why. Those were laws about gunpowder being just...
Again, why do you not get into what the gunpowder was used for? Why not get into the fact, yes, these were fire ordinances about gunpowder, but this law proves at the time that people owned every single weapon that the government could own. It wasn't a restriction on arms themselves.
flammable in and of itself. It's a dangerous
Yes,
explosive.
it was a different danger because it was a danger that dealt with the technology at the time, and this is a parallel danger, but a different one that deals with the technology at this time. But in terms of burden, I think you'd have to agree that the burden of the gunpowder restrictions was much greater.
I mean, not necessarily. It depends what you're talking about. A lot of them were simply about how you stored your excess gunpowder, that it had to be in 4 canisters instead of 1. That's not a restriction on your ability to use the gunpowder when you want to fire the firearm.
But you have to go get it.
You have to go get it, but I mean, they're really about the storage.
So in
not
terms of delays, there's obviously if you can't store the gunpowder in the gun, and apparently in many instances you couldn't store it. Sometimes
Again, Your Honor, these were fire ordinances because houses were really close together and they were all made out of fucking wood. So they wanted to make sure that retard number 1 wasn't storing all of his gunpowder next to fucking lit lamps so that when it burned his house down, it burned everybody else's house down. It was not a restriction on owning gunpowder. It wasn't a restriction on the types of weapons you could own. It's merely a fire ordinance. And I do have some issues with that because that logic could be taken to today to how you store your live ammunition and the government having a say-so in that. Just there's differences and little nuances there to look at. But the major one is there was no restriction on the types of arms you could own. They didn't say you can't own that cannon unless that motherfucker's got a loaded chamber indicator on it. It wasn't saying you can't own that. People don't understand. Mortars. You're talking about a cannon-like device that launches explosive shells, and that is what your average citizen owned. I don't see why the lawyers for the appellants, the lawyers for us, I don't see why in every single fucking case that I have watched where this ordinance comes up, the Mass Act, I don't see why they don't break it down for the judges. Look, this was about how you stored your powder. All this act really does is prove that your average citizens owned every implement of war at that time. Again, cannons, mortars, grenades, bombs. That's all included in that act, and it wasn't saying that citizens can't own these things. Yeah, too many choices, 100%.
In a different building or in a different room, and so on.
With respect, most of the laws were not addressing what you could do vis-a-vis the gun. They were talking about your excess gunpowder when you're not using it with your firearm, if you kept extra around your house, or they're like zoning laws for gunpowder manufacturers.
But I
and
assume
such.
you're always keeping extra around your house. And my understanding is you can't leave the gunpowder in the gun because.
There were very few laws that actually
But
said
I
that
think
you couldn't do that.
you actually can't. It won't work. So you have to have the gunpowder somewhere, other than in the gun. And if it has to be, in a different room or off-site or in the basement, obviously that's going to take. It seems clear that the burden is greater.
I mean, I just think it's pretty hard to accept that when Heller considered those exact same laws and said that they just were not analogous to restrictions on the ability to have the gun in the first place. And this is a restriction on the ability to have the gun in the first place. So if they're not good enough there.
Again, Judge, stay with me here. I realize your IQ ain't the greatest, but these laws didn't restrict the arms citizens could own. Citizens owned all of the arms that the government could own. It wasn't just a musket. It wasn't just a pistol. It was cannons and mortars and swivel cannons and grenades and bombs. That's all listed in the Mass Act of what people owned. And even if the government brought them to a trial with a jury and decided that they were improperly storing their gunpowder, if they confiscated those arms, that mortar capable of launching explosive shells, if the government did confiscate that from a person, they sold it right back to the citizens. They did not restrict the citizens' ability to own these weapons of war. So we're talking about loaded chamber indicators and shit, and these people owned guns, owned mortars, owned cannons capable of reducing buildings to fucking rubble, and the government did not say they couldn't own those. They just said, hey, don't put the city in jeopardy of burning to the fucking ground because you're a dumbass.
It's a restriction on the ability to have a gun without the chamber indicator.
Correct. But either way, it's a restriction on the ability to have the gun at all. And Heller basically said, look.
Well, first of all, it's not a restriction on having the gun.
It is in the sense that it's restricting my ability to get the gun, which is inherently a restriction on my ability to have the gun. And I don't take the.
And again, remember, it only restricts my ability to go purchase that gun from a federally firearms dealer. I can still go buy that gun on the secondary market, more than likely from a police officer looking to make some extra money going into the business of dealing in guns. Don't forget, they are selling those guns for a profit because they're buying in them using their badge for $500 and something, but they're going to sell it to you for $700 and some change. But they're police officers. Makes it all better.
Exceptions in this law to exist because California really wants its citizens to go buy a bunch of these purportedly unsafe handguns on the secondary market. I mean, the ultimate goal of this law is to phase out the firearms that are possessed by law-abiding citizens in 49 other states in this country and have a completely different market in California that mandates features that aren't common.
Can I ask you a question about technology? Because, technology changes over time. So today, this is not a common law, but we can't predict the future. In 10 years, what happens if half the states decide, that's a good idea to have a CLI and MDM requirement? Does the analysis then change?
I think, I don't think at the end of the day, everything turns on how many states accept it. I think the more important question is how prevalent the technology is. And if the technology becomes prevalent in a way where, it's just really easy for people to get them. I mean, some of the laws that the less extreme approaches that California hasn't taken, where you might say, look, you gotta, if you have technology that's possible, kind of sell one with it, sell one without it, people still have a choice. But if you're mandating in a way where it's something the market is generally not producing, I think that's a real problem.
So the market is then becoming, and that's not the way consumer regulation usually operates. I mean, airbags are one example. Electric cars are another. The government decides that something has to happen for public safety reasons or in a climate change reason, and it gives people time. And you could quarrel with the timing, but you can be under microstamping. But if it's phased in, and if the manufacturers are given the opportunity to comply over time, eventually they comply. And if everything is market driven, it's very hard to understand why the Second Amendment makes the market the determinant of the scope of the right to bear arms.
Well, I mean, the first thing I would say is I'm not aware of any consumer product safety law under which the government says this is unsafe, but the government can use it. That's not typically what happens when you actually think a product is unsafe. So it's a little hard to understand this as a true consumer safety product law when they're saying everybody in the state of California.
Which is that the people who can use it are people who spend 600 hours in gun safety classes before they use it.
We're not talking about, like complex means of how you use a firearm. It's simply a question of checking whether your firearm is loaded, which is the first rule of gun safety.
Yes, but there are children and there are people who are not.
Sure, but generally,
it's not that it doesn't happen; it happens fairly frequently.
Damn, I forgot I was muted again. You can put in all of these laws to mandate safety options on something. Cars are a perfect example. Airbags, you name it. But think about a car, okay? Airbags are there in case you crash the vehicle. And it could be that someone else in another vehicle crashes into you. But even with all of those safety options, you still have thousands of deaths a year in vehicles because people are dumbasses and they have accidents. They're going to do 95 through a 35 with a sharp corner and run a school bus off the road. You can't mandate personal responsibility. Personal responsibility with me having a firearm, I am responsible for whatever I do with that firearm. I treat it as is if it is loaded at all times. Even if I clear the gun, I make sure there's no round in that son of a bitch. It is still treated like a loaded firearm. I make sure my finger does not get on that trigger until I am ready to shoot to destroy whatever is in front of that firearm. I make sure of what my target is. I'm trying to look at the background of it. Every bullet in that gun has a lawyer attached to it. But they're conflating a couple different things here. One is an item we use every day to get from point A to point B, vehicle. And whenever I'm in that vehicle, I am interacting with other vehicles on the road. There is no way around that. I carry my gun. My gun only interacts with me. It's not pointed at anybody else. It's pointed dead at my junk because I carry an appendix. But it's not pointed at anybody else. It doesn't interact with anybody else. Matter of fact, when I'm carrying, if I'm carrying properly concealed, no one else even knows it's there besides me. Or unless someone knows me and they know Coop's got his gun on him at all times. I'll have to take a picture next time there's a gas station I stop at all the time, just for a little side room. And there this gas station is a bit ghetto, but there are bullet holes in the big post holding up the awning above this gas station. You're trying to tell me people who are just shooting like that, they care about loaded chamber indicators or any of your fucking gun laws. Man, put every safety feature on a gun that you want. Criminals do not care about your safety.
Generally, consumer product safety laws are the concept is this is a product that is not fit for people to have. And there's an awful lot of people, I mean, there's not even a possession restriction, there's an awful lot of people here that California allows this product to continue to be sold to. And that right there requires a historical justification, and the state hasn't pointed to any historical law that's ever said certain
take
types of
airbags.
firearms.
That's not a determination the car isn't safe to drive. It's a determination is that it will be safer if it has airbags.
And again, we're in the realm of the Second Amendment, where the Supreme Court has said to look,
that's a back out.
You know,
I mean,
we've got a constitutionally protected
I
product.
understand that, but that's. I was talking about the question of whether the market runs everything.
Sure,
and
I
why
think
why the Second Amendment should incorporate the notion that the market runs everything is something I don't get.
Because the Supreme Court has the historical test for whether an arm is protected is whether it's in common use. And that is a test.
And see, I hate that argument. I hate that argument of this common use. And that is being argued right now and starting to be used about ARs, AKs, saying that they're not really in common use because there's over 400 and something million guns in the United States, and ARs and AKs are only a small percentage of those. So they're not really in common use. So, and stack that on top of it, the other attack is it only takes a matter of minutes to make one of these guns basically a machine gun. So therefore, they are readily convertible to machine guns. So if they're not in common use and they're readily convertible, they need to be under the NFA and they need to be banned. Those are arguments that are being used right now. Briefs are written right now for that. So I hate this idea of common use because they can literally argue this new gun isn't in common use, even though it's basically just the same gun. Maybe some parts are moved around. It's the same as all these other guns. But that is a way they could completely stop innovation in firearms. And that's one way that they want to go. I mean, if I made a gun right now, if I perfected caseless ammunition, they could say, that's not in common use. Those are new. We can't have those. That's not common use. So therefore, we could ban those.
That ask, is this something that the people choose? and that makes some historical sense when you're thinking about the point of this was an amendment that protects the ability to possess something and protects you against the government taking it away. It would seem awfully problematic if the government gets to decide at the front end which things you can and can't
So
possess.
if over time, if in 10 years, consumers have a different perspective, they decide, no, these are actually features that we want, and it turns out manufacturers cater to that and start to produce more of those, and the amount of pistols that are on the market that don't have these features turns out to be the minority. Does the analysis at that point change for people like your clients?
So I think, to take the two pieces historically of the how and the why, we're still going to have the same debate about the why. But assuming there were analogous why laws, the burden on the how,
that judge on the top right kills me, man. I didn't notice it the first time I watched this.
This would be a different case.
But she's completely checked out.
It's a little bit different.
I'm sorry, I didn't hear what you're saying. If
we were challenging safeties, I mean, it does matter under Bruin. You're judging. You do.
Think about this. So, the 1911. So 1911, I have a grip safety on it, out of battery. I have a thumb safety on it. The gun is an extremely safe gun. Compare that to something like a Glock, where basically I have a trigger safety on it. I have drop safety. I don't have any external safeties. Think about how popular Glocks are versus 1911. People don't like having those extra safeties. I don't mind them. I mean, I love my 1911. It's extremely accurate gun. It's an extremely safe gun. But, I don't have the magazine capacity on that. That's one of the reasons I went to carrying a 19 size gun. I don't have the magazine capacity on the 1911, and it's just differences in between the guns. But I still carry a safe gun. These people act like the manufacturers are driving demand instead of the way it actually is, where consumers drive the demand. Consumers want these newer firearms. They want them without the external safeties. They want them to be less complicated so that there's less that will malfunction.
Look at the degree of the burden. Now, unlike
The point being, safeties are just common and everywhere at this point.
We don't have a record here about it, but I think it would be a different case, and there may be stronger arguments about the degree of the burden and how that burden is comparable or not historically. And that, yes, Bruin changed the analysis in the sense that you have to look at the degree of the burden as compared historically, but you still do look at the degree of the burden, and that may be different today versus 10 years down the road versus 50 years down.
I did want to get your perspective. The state was emphasizing the number of pistols that have been added to the roster more recently that have the CLI and the MDM, both the 32 plus the more recent ones. What is your position on the relevance of that?
I don't really think it matters, because the ultimate question is here is whether we have a constitutional right to purchase the pistols that aren't on the roster. And I don't think that really changes the bottom line about whether we do. That said, I will note, as the district court found, after considering a record here about lots of things, including lots of testimony about feasibility, but the district court found that those numbers are pretty inflated because of the way this law works, such that it double counts things if they come in a different color and such. So the number of available truly different models, even among the now, I guess it's 37, is pretty overstated, just as the number of the 300 or so on the roster is itself overstated for exactly the same reason. I see my time.
Do you want
is
to
up.
briefly address, we've been keeping away from the microstamping, but I asked in the last argument, if we thought on this record that we basically had no useful information about the feasibility question, which the meaning, I gather, we do know that it's technologically feasible, but there's some notion that it's not commercially feasible because each manufacturer has to figure it out for himself. Figure out how to apply it to their particular gun or guns. And as I noted, the person who testified in this case was not qualified as an expert and didn't seem to have, there's nothing to suggest that he had any information since 2005. So if you want to comment upon that, that's good. That's
Sure. I would actually very much resist that characterization of the record. He was specifically asked, has there been technological developments since 2005, and discussed this in his testimony.
But there was no evidence that he knew anything. Had he ever seen a gun since, one of these guns since then?
That's not, I don't think that's a fair characterization of his testimony. He's worked in this area, and he talked about his knowledge that there hadn't been any developments. We also had testimony from somebody from NSSF, the manufacturer trade industry, that talked about why this hasn't been commercially feasible. And what he explained, what Mr. Beto explained, is it's feasible in the abstract sense, but in order to satisfy California law, for one thing, it has to pass the test like hundreds of times. And it may be feasible that you can do it a few times, but it's not feasible.
I thought that the 2005 study showed that hundreds of times with many of the guns, it worked 95% of the time or 90% of the time.
There's been some of the guns for which that has worked and others for which it hasn't. The other impediments are, it's not just that there's lots of different firearms. You can use different ammunition with different firearms, and the different ammunition can have an impact. So you have to be able to develop it to work.
My ultimate question is, if we thought we were at zero, if we thought that there was no useful information, because the state didn't put on anything,
That's
really,
correct.
except its legislative findings. how conceptual?
Trying to
is
look for
that?
this other case that I had to
I
listen
think to the extent feasibility matters, that means the state loses because it's unquestionably the state's burden to prove that this isn't imposed, that this is consistent with historical tradition, that it's not imposing a greater burden than historical laws. They declined to put on any evidence about the degree of burden that this is actually imposing, so I think they lose. That said, there was a 2-day evidentiary hearing here. The district court made a factual finding. That is a factual finding based on testimony that is subject to clear error review.
Well, I know, and I'm assuming, for present purposes, I'm assuming that there was arguably clear error because there is not much evidence of what he said he found.
And I would just encourage
but
you to
leaving
go.
that aside, let's assuming that, I want to know what the conceptual, and I understand your answer now.
Yeah, and my answer is if they didn't put on any
case.
evidence, even if you didn't think our evidence is sufficient, it's their burden, not ours, given that this is a law that implicates constitutionally protected.
Because you think everything is shifted over to the history side. So if it were on the
I think
other
I
side,
saved
we're
it to
the
watch
burden,
later.
we're on the prong one.
I mean, at that point, I guess I would say if you think we have some sort of burden to prove that this is infeasible, I think we met it. I mean, we put on multiple witnesses who provided testimony that a district court heard a whole day of testimony about and decided they were credible and proven to him that this was not feasible on a
But your
commercial
witness
scale.
was not, every other one of the witnesses was specifically qualified as an expert. He was not.
I'm not really sure why that makes a big difference. I mean, the state wants to rely on him as an expert when it comes to the question of whether it's feasible in their conception of feasibility, then turn around and say he doesn't know what he's talking about when it comes to whether it's feasible on a mass scale. I don't really think they can have it both ways.
Okay, thank you.
I think we've let you go over your time, so I want to thank you, Ms. Murphy, for your argument this morning, and we'll hear rebuttal.
Thank you.
A few points, Your Honors. I believe I heard my colleague say that nobody wants a defective gun or a gun that's not subject to drop safety testing. But I think it's important to remember that in the Boland case, the plaintiff's complaint actually challenges the entire Unsafe Handgun Act. They are challenging the drop safety test, the firing test, and the safety requirement.
Is that correct?
The complaint challenges every aspect of the Unsafe Handgun Act.
Right, but the injunction that's before us doesn't enjoin the rest of it.
It does not, but Renna, the plaintiffs in Renna, sought to enjoin the entire Unsafe Handgun Act, and the district court did reject those arguments. But I think if you were to accept plaintiff's view as to what the plain text inquiry is, I think they are using that for those other features of the Unsafe Handgun Act, including the drop safety, firing tests, and the safety device requement.
Safety what requirement?
The safety device requirement.
I'm not sure I'm following the point you're trying to make. I want to make sure I understand where you're going here.
My point is that plaintiffs are saying that they don't want access. I think what I heard being said is that they don't want to buy defective pistols.
I don't know where I
The fact
saved
that they're
this
challenging
freaking
those other
argument
three
at.
requirements as well, I think is inconsistent with that statement.
And I guess you're also making kind of a slippery slope argument.
That is correct as well, Your Honor, yes. I mean, the safety device requirement,
The court or the state making a slippery slope argument is absolutely fucking hysterical. Kaisel, what's happening, brother? We'll learn how to pronounce names one of these days. Yeah, hundreds of times, hundreds of rounds. Yeah, not even a trip to the range. Yeah. Because seriously, if I go to the range to train, it could be just training with, rifle that day. I'm going to fire quite a few hundred rounds. If I'm training a rifle pistol, I'm more than likely going to train to where that day I'm firing well over 1,000 rounds. Just depends on the day that I'm training and exactly what I'm training on. But yeah, too many choices. Sometimes it seems like they're kind of making the state's case sometimes. It's why I say when we're arguing or when they bring up the Mass Act, they ought to argue on the fact that people owned all of these different weapons, and it wasn't a prohibition on weapons. It was simply a fire ordinance. That's all it was. It wasn't the state saying you can't own these things. I guess there's a lot of times where lawyers being lawyers, they may know some things they do know some things that I don't, but I still don't see why they don't argue these cases a bit different sometimes and really try to put the state back on their heels. I don't see why we can't argue cases based on the Interstate Commerce Clause. The government uses it against us. Why can't we use it against them? Hey, government, you are stopping millions of dollars in legal commerce by stopping Polymer 80 from selling their kits. You're putting hundreds of people out of work. You are negatively affecting interstate commerce. And for people who don't realize, the standing is a big thing. I don't see why we can't argue some of these cases a little bit more in the face of the state. In other words, really getting into their goddamn grill on this shit. And a lot of people don't realize that most of the federal gun control is based on the Commerce Clause, because the federal government can't regulate shit unless it is actually changing in commerce or traveling in commerce in between states. So when you read a lot of gun control, they always mention the Commerce Clause. These things have moved in interstate commerce. The case that I'm trying to find that I listened to the other day had some to do with that, had to do with ghost guns and interstate commerce. So I'm trying to find that. I saved it and I can't remember where the fuck I saved it at, because it wasn't listed by case name and all that. It just came up in a series of arguments. So I'm trying to find that. And when I do find it, I'm going to do a pretty good video on that. I've got to find the damn case. I've done so much and I'm horrible, like a fucking squirrel, man. I bury acorns everywhere, and then I'm lucky if I find the sons of bitches later. It's just, I could hide my own fucking Easter eggs. Oh yeah, dude. Well, you're dealing with the Seventh Circuit, and then you're looking at the Ninth Circuit here. You have two judges that are decently engaged, and you have another judge who's completely checked the fuck out. She already knows how she's going to write her opinion on this. She already knows that she's going to go with the state. Fuck your rights. And these people are so disconnected from these things. You think any of them knows jack shit about a firearm? You think that they've carried one for self-defense or that they've gone through training for firearms? They damn sure haven't built firearms. They have no idea about firearms technology. These are the people governing your rights. That's why the Constitution and the text of the Constitution is what's supposed to matter. So that someone who knows jack shit about guns can read the Second Amendment and look at a law and go, wait a second, this says shall not be infringed. Your law is an infringement, so your law doesn't count. I don't have to know the subject. I just have to be able to read the text. Which I haven't applied my certified welding inspector credentials that much. But if I'm looking at someone's weld and I'm inspecting it, I take what is in the text of the standard, which is really a legal document, and I look at their weld and I apply the standard. It doesn't matter whether I like the person. It doesn't matter whether I like how the weld looks. It doesn't matter if I like how much time it took them or anything like that. I have a standard. That standard says that this weld can only have, so many inches of undercut, and that undercut can only be, 32nd of an inch deep, and anything other than that, I can't. It could have undercut in certain places. It can be an ugly looking weld, but as long as it passes what is in the text of that standard, then it's good. My personal opinion about it does not enter the equation. That is the way the law should work. This is the Second Amendment. This is this law. If this law does not fit into the plain text of this amendment, then that law is null and void. Otherwise, and we run into this all the time, where every law passed, quotation marks, is treated like it's constitutional until you have someone withstanding, like Too Many Choices mentioned earlier, to fight the law. And then if you have judges who simply don't like something, they can agree with the state's case, and then it is treated as if it is constitutional, even though it doesn't fit into that text. It's not within those guide rails that are supposed to be put on government. Government is supposed to be about like a train. It has tracks that it runs on. It can't just decide at a moment's notice to go bang a right-hand turn if the tracks are going straight. It can't. However, we have people who believe that the government can just lay their own tracks and go wherever the fuck they want. It's not the way this is supposed to work. If the Constitution had any teeth whatsoever, judges that support or uphold unconstitutional laws would be removed from the bench. Thanks for fucking playing. Apparently you can't read, or your level of understanding of written content is too low for you to preside over these cases. Go fuck yourself. Anybody who writes a law that does not match up with the Constitution, well, they should be slapped right out of office. If that law passes and that law is upheld and people actually suffer, go to jail, have to pay fines, lose their property because of that law, when that law is ultimately found to be unconstitutional, the people that wrote the law, the judges that upheld the law, should all go to fucking prison. Yes, Too Many Choices. Yes, she would already be in prison. The minute she wrote that order, the minute she made that shit official, there should have been a sheriff that politely walked into her office, put handcuffs on her, and threw her ass in fucking jail. You have broken your oath to uphold and defend the Constitution. Thanks for playing. You are never allowed to hold office again, ever, 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 ever. Matter of fact, these people should lose all of their civil rights to vote, to own arms, to anything else, because they have already proven they don't give a rat's ass about the Constitution in the first place.
It's called a positive manually operated safety device. It also prevents accidental discharges. That is the point of it, is to ensure.
Crow, no, that's the sad part. You see, a sheriff, literally, in my opinion, when one of these people tries to pass an unconstitutional law, should walk in there and be able to arrest them. Cops, people who are actually on the ground, the front line, supposedly enforcing laws, should have to be more knowledgeable about the Constitution than anybody else, so that when they have a law come through that is unconstitutional, they should be able to say, no, we're not enforcing that because that is unconstitutional. And if an officer does enforce an unconstitutional law, their ass ought to go to fucking prison. It should be legal, 100% legal. And it actually is, although it won't get treated that way. For me to use force to defend my constitutional rights against anybody, whether or not they have a badge on or not. See, that's why banning guns is this big push from those on the left, because they want the government to have a monopoly on force. And this whole idea, well, or cops, well, I'm just enforcing the law. That law was passed. It was legally passed. Well, I'm sorry. Even if that law was so-called legally passed, if it is unconstitutional by the state constitution or the federal constitution, then that law should be null and void. And any officer that enforces these unconstitutional laws should go to fucking prison, because they have imprisoned people, they have detained people, they have put handcuffs on people, thrown people in jail, taken their safety, taken their property, taken their liberty for something that is unconstitutional.
That the gun only fires when the trigger is pulled, and that is also the
Yeah, that's another huge one. Choices is the qualified immunity. They shouldn't have any more immunity from prosecution than I do. If I use my gun to unduly deprive someone else of life, liberty, or property, I'm liable for that shit, and my ass gets to go to prison. If they use their gun to unduly deprive someone of life, liberty, or property, they should be treated the same. But see, they don't want that. They don't want people to have a right or the power to be able to stand up against the government. I need to do a show on the one of the Bundy standoffs, the first one, where you had the federal government come in trying to put these ranchers in jail, trying to take their freedom, and you had a bunch of people, even some well-known people like Jim Fuller and James Yeager, we just lost not too long back. They actually showed up to that standoff armed, ready to stand up against the federal government. People don't realize those guys actually put their fucking money where their mouth is. They put their fucking nuts on the chopping block and went down there with their firearms to stand up against the government. And the government doesn't like that. They don't like it when the people just don't roll over.
point of the drop safety test as well. And there's a lot of reliance, I think, on Bruin and saying that common use is sufficient in and of itself. But I think Justice Alito's concurrence in that case made clear that Bruin was saying nothing about which weapons were protected and which weapons are not protected. And so common use may be necessary for the plain text inquiry, but it's certainly not sufficient in and of itself. The historical arguments, I don't think I'm going to address them point by point. I'll just say, overarching, I think the arguments here are still asking for a historical twin, even though I think I heard an acknowledgement that there are dramatic technological changes here. But regardless of which approach or which standard is being applied, I think Bruin made clear that a historical twin is not required. And I think there was also a suggestion that Heller wrote off wholesale gunpowder storage regulations. I don't think it wrote it off wholesale as for historical analog. It was just saying it was not analogous for the regulation at issue in Heller. Analysis points that were discussed in the...
If you have technology that's possible...
About the question,
We've
been keeping expert and didn't 95%.
I think we've
and the safety device requirement.
Okay, Bruin didn't write off those or ordinances. Come here, Bob. Here. Here's some pretzels. You're just not getting the full bag of pretzels. I know what's going to happen. I'm going to end up with pretzels everywhere. Anyway, Bruin didn't write off those things. Bruin kind of made a distinction that, or Heller, those were completely separate from this. Those were firearm ordinances. Those didn't dictate what the people could own or how they could carry them or how they could actually use them.
Requirement.
The safety what requirement?
The safety device requirement.
I'm not sure I'm following the point you're trying to make. I want to make sure I understand where you're going here.
My point is that plaintiffs are saying that they don't want access. I think what I heard being said is that they don't want to buy defective pistols. But the fact that they're challenging those other three requirements as well.
No, what is being challenged is the government's restriction on what they can and cannot own. They're not saying they don't want a gun that's drop safe. They're saying that is between them and who they choose to purchase the firearm from. And if it is safe enough for an officer to purchase and carry every day on his job, then it's safe enough for me to purchase and to use in my private life. It's again, the state always plays this game of hide and go fuck yourself, and they win. It's like playing Monopoly with a fucking 6-year-old. You can't put a hotel there. You haven't even put a house on there. Well, fuck you. I'm 6 years old. I'm going to put a hotel there. Matter of fact, I'll put 2 there. And then even if you land on the square next to it, you still have to pay the bill for the hotels because I'm 6 and I'm the god of this goddamn game. If you don't like it, I'll flip the whole board over and cry. Shit my pants, and you'll have to deal with that. It can be an us problem real fast.
I think
Okay.
is inconsistent with that.
And I guess you're also making kind of a slippery slope argument.
That is correct as well, Your Honor, yes. I mean, the safety device requirement, it's called a positive manually operated safety device. It also prevents accidental discharges. That is the point of it, is to ensure that the gun only fires when the trigger is pulled. And that is also the point of the drop safety.
Yes, most firearms don't fire unless you pull the trigger. Ask Alec Baldwin. A magazine disconnect doesn't do anything to make a firearm more safe. There's nothing to do with that. You can have a gun with a magazine disconnect and you can still pull the trigger and shoot your fucking neighbor.
Test as well. And there's a lot of reliance, I think, on Bruin and
Well, Brandon Lee got shot by somebody else. He didn't pull an Alec Baldwin and just go, point a gun that he knew was a functioning firearm at somebody and then pull the goddamn trigger. So Alec Baldwin knew that gun was a fully functional firearm. They had taken that firearm when they weren't filming and loaded it up and practiced target shooting with the damn thing. They knew that was a fully functional firearm. Alec Baldwin, being a dumbass, pointed a fully functional firearm at somebody and then pulled the goddamn trigger. Brandon Lee was acting, and I don't know, there's so much tangled shit that I've heard about it and so many different rumors. But anyway, he caught a projectile.
and saying that common use is sufficient in and of itself. But I think Justice Alito's concurrence in that case made clear that Bruin was saying nothing about which weapons were protected and which weapons are not protected.
Yeah, that's what I heard, Crow, was it was a barrel obstruction. Again, in filming movies and stuff, they do use real firearms sometimes that are supposed to be checked out by qualified people. And from one thing I heard was they use rounds that are basically rounds without the primer, or maybe a primed round with no gunpowder, supposed to make a pop, or anyway, it caused a barrel obstruction, and then the next dummy round fired, the primer, just the pressure of the primer was enough to force the projectile out of the barrel and ultimately get him. This is a very weird situation when Brandon Lee got killed. And The Crow was, man, that's still one of my all-time favorite movies. But yeah, it was really a weird situation with Brandon Lee. Not so much when Alec Baldwin shoots people, because he had a firearm in his hand, hammer back, pulled the trigger.
And so common use may be necessary for the plain text inquiry, but it's certainly not sufficient in and of itself. The historical arguments, I don't think I'm going to address them point by point. I'll just say, overarching, I think the arguments here are still asking for a historical twin, even though I think I heard the acknowledgement that there are dramatic technological changes here. But regardless of which approach or which standard is being applied, or I think Bruin made clear that a historical twin is not required. And I think there was also a suggestion that Heller wrote off wholesale gunpowder storage regulations. I don't think it wrote it off wholesale as for historical analog. It was just saying it was not analogous for the regulation at issue in Heller. And I think about Mr. Beto's testimony, he did test 6 different pistols from one manufacturer. He tested 5 pistols from 5 individual other manufacturers. He used different ammo. And I think our reliance on Mr. Beto is not a concession or acknowledgement that we think he is a qualified expert here. I think our point in pointing to Mr. Beto's study and his testimony is to show that there was clear factual error here, and that the district court was simply unsupported in its factual findings. And one example is where the court said that Mr. Beto testified that something along the lines, I have the quote, is that commercial implementation was not possible. And he said it was not suitable for mass implementation at that time, which was 2005, so 18 years ago. And a lot has changed since, I think,
And
since
was there
2005.
any indication that he had done any separate consideration since that time?
Of the microstamping requirement?
Yes.
Not that I'm aware of, Your Honor.
Well, he made a statement about the present, but there was nothing to back it up about what had happened in the ensuing 18 years.
I think his statement was that in the course of conduct of his job as a ballistics examiner, he had not seen a microstamp pistol come across his desk. I think that was
Right, so he hadn't seen when he hadn't tested one.
correct.
Yes.
He has
I mean,
not tested.
what more is he supposed to say? I mean, there's an absence of development. I mean, he said, he was basically asked, are you aware of any developments? And he said he's not aware of any.
Correct, but he hasn't been involved. He lives in Arizona. He was not familiar with some of the California requirements. And at that time in 2005, when he studied microstamping, he said that the way California had developed the regulations related to microstamping, where it uses alphanumeric characters, that method had the best possible chance for mass commercial implementation. And so and he has not been involved in testing any microstamping since then. He's not been involved in any studies.
I still gotta
whatsoever
find this
since then.
fucking
So I think
case that I'm
my
trying
point
to
about the
find.
Beto study is that it just simply does not support a conclusion by the district court that microstamping is forever not commercially, feasible. And I think, again, like I said before, any ruling on microstamping should be limited to what is in the record here, rather than a broad statement about, the feasibility and commercial availability of microstamping.
Let me see if my colleagues have any further questions for you.
I do not.
Okay, I want to thank you for your argument this morning. I want to thank both counsel for the briefing and argument. This matter is submitted, and this concludes our calendar for this morning. We'll stand in recess until tomorrow morning. Thank you both.
Thank you.
All right.
So those were the 2 arguments in the handgun roster case in California. And I don't know where everything's at now. And of course, we're still expecting a bunch of activity from California with Judge Benitez. He's still working on writing out opinions on some cases. And that's going to get really interesting to see where that goes, because Bonta's fixing to, he's getting slapped around right and left, or the state of California, and Rob Bonta is. So we'll see. Sam, what's up, brother man? So we'll see where all this goes. The rest of this year, I think, is going to be decently busy with a lot of these cases and opinions coming down. And then we'll see this next session with the Supreme Court, what cases they take up. As far as I know, the Rahimi case is still out there with the Supreme Court. I don't think there's been oral arguments in there yet. I'll have to search and see. And as soon as I find them, or as soon as that pops up, then I'll do do a stream on those. And give me a second, guys. Let me see. I'm still looking for this fucking case, and I can't remember where I saved it at. Oh, Tony Simon's over there with G-Webs right now. And I'll have to find this case and do a video just on that particular case. It's somewhere in my freaking saved videos, but I will be damned if I can remember where it's at. Keep looking, thinking I can find it real fast, and I haven't been able to find it yet. Because I can't. Hold on, let me listen to something. No, that's not it. And this is the same panel of judges. No. All right. You will have to ask Mama on that, baby. Oh, man, I hate that I can't find this thing right away. But I'm going to do... It might be good that I can't find it right now, because I'm going to do a whole live just on that case. And to break it down, I've talked about it in another stream. It was a guy who had got out of prison. Yes, he was a felon. Apparently, he had built some guns, sold some guns to some people, so ghost guns. And it was funny the way the state, because it was a federal prosecution. It's funny the way they went after him. I think they went after him for selling the guns, but they didn't hit him with like a felon in possession, because kind of rightfully so, his defense attorneys argued that these guns hadn't moved in interstate commerce, so the federal government didn't have any sway over or any power over those guns, since they hadn't moved in interstate commerce. And the state didn't charge him with the ghost guns, but what they did is during sentencing, they used him being in possession of the ghost guns to sentence him at a higher rate. I'm kind of losing track of some stuff. But anyway, they didn't use him to charge him. They used him during sentencing as a sentence enhancement. That's what I was looking for. And I think the reason they did that is the state didn't want to say, hey, you were in possession of these ghost guns illegally, because they didn't want to have to go on the basis of whether or not these guns had moved in interstate commerce and argue on that. But they did use them during a sentence enhancement. And to me, if you can't use them during his initial charges, how can you use them as a sentencing enhancement? It's kind of a funny case. So I'm gonna try to find that and dig up some more about it, and I'm gonna do probably another live on that, just because it was interesting that the state didn't charge them with the guns, but they used them as a sentencing enhancement. So it's one of those cases that I run into because I subscribe to these courts. So pretty much every day these courts are in session, I've got them popping up on my phone, and I'll pick through them to see whether there's anything really interesting. And I just basically tripped and hit my head on this case. And I thought I saved it in one place, and now I don't see it, so I'm going to have to go back and look. There's a new one coming out, mandatory February 1, 24. Okay, yeah. yeah, so we'll be on the lookout for those. And of course, if any of you guys see any interesting cases, do like Warsaw. Warsaw sends me stuff all the time. And I've got to get back and cover some more of that. I thought I'd already covered the oral arguments coming out of the Seventh Circuit about the assault weapons ban and stuff, and we may hit those again just because those. To me, it's interesting looking at the way the state argues stuff versus how the lawyers for our rights actually argue these things. Anyway, so you guys keep an eye out tonight, man. You guys all please follow Polite Society Podcast with Paul. I'm not sure he's going to have on tonight. I had the opportunity to be there, but there's one thing that would really stop me from being on the show, which is an alligator hunt, and I'm going to be on an alligator hunt tonight. So may shoot some video tonight on the alligator hunt to show everybody how that goes. See if we get on another big gator. Last weekend, we had a chance to take a 9-footer, but that 9-footer's a little small. I know that sounds funny. A 9-foot alligator small. Yeah. Compared to some of the gators that we've been on, yeah, that 9-footer was small. So we'll see what we're running to tonight. And hopefully, hopefully, we can get on a big boy and I'll shoot some video of that. So other than that, man, I'm getting out of here. I got just a little bit longer and I got to finish getting ready to go on this hunt tonight. So you guys be cool. I did leave links in the description down here for the case text for these two cases in case anybody wanted to breeze through some of that. Matt, what's up, brother? Yeah, dude. Last year we lost damn near all the meat from the alligator because the freezer decided to just fuck off and quit working. So yeah, that sucked. But this is a buddy's tag. Pretty much anytime friends of mine get tags, they'll call me up because they know I will alligator hunt at a drop of a hat. So that's what we're doing tonight. So this freezer is on him. So we'll see how everything goes. But yeah, slip over, you guys, if you don't follow Polite Society Podcast. Let me do something real quick. Hold on. Let me post this because really and truly, you guys, if you're not following Polite Society Podcast, and of course, Paul is the new media director for the Second Amendment Foundation. So you guys really, let me see. I'm going to throw it down here. So you guys give Paul and the crew a follow. I don't know who he's got on tonight. I don't know whether Tony Simon will be on there. Rob Latham. Again, Rob is a great guy to follow. He does the self-defense gun stories. Another one, if you're not following, you really need to be following. Matter of fact, let me see whether I can find that real quick. Oops, shit. Tipping shit over. I'll throw it out there for this is Apple Podcast, but you can follow them anywhere you can follow podcasts. Yeah, baby.
Spell iCup.
Huh?
Spell iCup.
iCup?
Yeah.
ICUP?
I meant you say ICUP.
I just got dad joked by my kid. ICUP. I just literally got dad joked live by my kid. Can't tell me that's not funny. But anyway, yeah, follow self-defense gun stories, guys. You got a worse one. But yeah, self-defense gun stories, guys. If you don't know them, follow them. They go through stories that are in the media all the time about defensive gun uses, and they'll go through, kind of lay out what happened during the self-defense or the defense use. Yeah, I know that one, Warsaw. I used that one on CRS one night, and got him to say it a few times. Him and Dark were on. And I got CRS. I got Matt to say it, and had him messed up with it. I gotta find that damn clip now that I think of it. And of course, we all know what's going on with CRS. That's the free CRS cut up there. So we all know that they're just getting screwed over. So yeah, that's going to be another rough one. What else? There was another thing I was going to post real fast. And man, I could post so many, Washington gun law. Let's do this. So this is going on right now. This is G Webbs. He's on there. Tony Simon's on with him. So if you guys want to kick over and watch something, that's another good one. ISO for King Weetada. Yep. American Freedom Society. Man, there's so many good channels I could post. That's just a couple. So follow Polite Society Podcast. If you want to go over and watch something happening right now, G Webbs is on. I believe Tony Simon's on with him. Look up self-defense gun stories. Follow them. Rob and the guys are great over there at highlighting self-defense gun uses. And really the stories they go through kind of help you war game out what you would do in a given situation. You're home at, in the afternoon and someone kicks in your door, or, it's late at night. What do you do with an intruder? There's all sorts of things that they cover. And it's really, really good, and it's very practical information. Thank you. Give 5. All right, guys. Well, Perps, I'm going to get out of here. I got to get ready to finish getting ready to go on this gator hunt tonight, and hopefully I will have some good content for you guys after that. So, as always, we will end this one as you Perps be cool. Keep that thing on you at all times. And you guys be safe, man. Much love for each and every one of you guys. Y'all be cool. And as soon as I can find this other video, I'm going to throw together some content on that. So I'm out. Much love. Y'all be cool. Be safe. Say bye. Say be cool, Perps. Hold on. Come here. Tell them be cool, Perps. That's just not going to do it. All right, guys. You guys take them easy, man. Love you guys. Later.